Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. Going to Florida today for the sentencing on Ashley Benefield. Mod zero tolerance policy. Today's zero tolerance policy. And before you start with the comments, whoever's in here is going to say, "You look tired. Are you okay? You look like you were crying." No, I just literally woke up. I have my cleaning people today, so I had to pre-clean the house. You know how that is. It's kind of like doing your hair before you go to the hairdresser. So yeah, this is no makeup. I'm fine. I haven't been crying. I'm tired, but we're all tired. When you're a mother who does everything, you're tired. When you're a mother who's both mother and father, you do everything. So as you can see, it's already a mood. Ashley Benefield's motion for new trial was denied late yesterday. I was going to come on and talk about it with you, but after being on the air for at least 3 to 4 hours in the morning, doing the Aiden Carney hearing, and then another 3 to 4 hours in the afternoon. Oh, you're so lucky to be in California, Lori. I wish I was in California. What did we do yesterday afternoon? We did another show yesterday afternoon that was like 3 or 4 hours long. And then by the time people started coming into the comments and saying things like, could you stop talking over the feed? I was on my last nerve. It's like, no, it was a live Zoom. And then it was court TV with commercials. I could not stop I could not pause the feed. Couldn't pause it. So Scott, you probably had to clean some stuff up yesterday of my own snarkiness in the comments, and I apologize for that. But anyway, good morning. The judge did not find her reason about the juror 15 to be compelling. We're gonna go over that later because I have some thoughts about it. My thought was that he was going to it was a long day yesterday, dude, Scott, and then Scott called into Young Jerks, and that was fun. Please, if you're trying to derail me about other things like Sarah, I can't even think straight right now. So the judge did not find Ashley's reasons about juror 15 to be compelling, and it's a long decision. I'm thinking maybe, I don't know. We can always hope he's going to go light on sentencing, and that's why he didn't grant the new trial, because he knew what he was going to do, and then he was just kind of like, all right, if I grant a new trial, it's just going to delay everything. But in my opinion only, based on the 11-page decision of this judge, I was like, juror 15 lied. And I find that to be a compelling reason, in my opinion, regardless of how I feel about Ashley Benefield. I think that in any case, I thought Alec Baldwin, I thought Alec Murdaugh should probably have gotten a new trial. And I don't know what happened there. Or is it going up to the Supreme Court of the Low Country? I can't even keep it straight anymore. Oh, thank you. Thank you, Joyful. I appreciate that. Usually I have some time in the morning to get ready. And then if you go on Twitter, there's all kinds of people. They took some picture of me from that fundraiser of Karen Reed, and they did something to it. They put it through some like effed up filter, and then they started putting pictures of it like side by side with my headshot. And they're like, she uses 1 million filters. Look at her. She's 150 years old. Like I have zero tolerance. Zero tolerance. Yes, exactly. Exactly. I'm a cat. If they don't want comments, find another place to watch. Yeah, there was one comment. I just can't. Like the comments about my physical appearance on Twitter right now are insane. Are insane. And then people came in to tell me that that the yellow cottage cheese guy was like trash talking me last night and replaying my stream. And it's like, okay, instead of coming over here to tattle and to tell me that other people are talking trash about me, why not just go over there and defend me? Why not do that? It's like when you're in like middle school and people are like, oh, so and so hates you. So and so so and so said this about you. Like I don't have time for that shit. I am the mother of 3 teenagers, and I don't have time. So I don't know why everyone just can't be nice. I don't know. I don't know why people can't be nice, but apparently they can't. The haters are one, and you say ignore them, but not, I mean that's great. That's great, but I'm also not going to let them get away with it. I'm not going to let them get away with publicly trashing me. I'm just not. It's not the way it works in my world. So thank you. I appreciate that. But yeah, it's insane. And that's it. And I don't know, who knows what Eva Benefield is going to get up and say today. And who knows what kind of trolls are lurking in the chat, my friends. But I'm zero tolerance. Zero. Exactly. They all give me the views, Jen. They give me the views. Like Kevin, Yellow Cottage Cheese, just restreamed my stream and just let his people in his chat, the 30 people that were watching, just trash me. Here's Ashley. Good morning, Ashley. She looks surprisingly well.
All right, good morning.
Thank you,
We're here in case 2020 CF 301.
Already the volume is going to suck.
Ashley Benefield. Ms. Benefield is here present in court along with her attorneys, Mr. Taylor and Mr. Pinnell. Present for the state is Ms. O'Donnell and Ms. Friel.
Evil stepsister.
Ms. Benefield was found guilty by the jury on July 30th, 2024 of manslaughter with a weapon. It's a lesser included offense of the original charge, and it's a felony of the second degree. The jury did make factual findings of actual possession of a firearm, discharge of a firearm, and causation of death or serious bodily injury with a firearm. As a result, the statutory maximum becomes 30 years. Let me go over what I've reviewed in anticipation of sentencing, and then the state and defense could tell me if there's anything that I was supposed to get and review that I have not. I reviewed the information in the file as well as the verdict form. I reviewed a score sheet that I believe was provided as a part of the sentencing memo. I don't have the original from the state. If you could hand that up. I reviewed the pre-sentence investigation. And Mr. Taylor, I know in your sentencing memo, you had referenced various mistakes and inaccuracies throughout your presentation. If you want to point those out and what you disagree with, please feel free to do so. I've also reviewed the court file to watch the progress of the case and the events that have occurred. I did review the defendant's sentencing memorandum and the attachments, including case law, letters, and emails. All right, Mr. Taylor, have you had sufficient time to prepare, and are you ready to go this morning?
Yes.
All right. State, have you had sufficient time to prepare, and are you ready to go this morning?
Yes.
So the score sheet that's been handed up appears to be the same one that was attached to the defendant's sentence memorandum. It's got manslaughter with a weapon. That's a level 8 offense, 74 points. The victim injury points are scored at 120. Total sentence points of 194. Once you put through the sentence computation, gives a lowest permissible prison sentence of 124.5 months in Florida State Prison. Any objections to the score sheet?
No, sir.
So I know this defense, you received the PSI because you had mentioned it in your sentencing memo. State, did you get a copy of it?
I did.
All right. Same as I told Mr. Taylor, if there's any objections, additions, corrections, deletions that you want to mention, please feel free to do so throughout your presentation today. So how I do these sentencings, whenever I have an open plea or if it's a sentencing after trial and the defense is going to seek a downward departure, I generally start with the defense, presentation of evidence, then I go to the state, and then I come back to the defense, just because you carry the evidentiary burden. I'm sure you've discussed this with Ms. Benefield, but just so I have it on the record, Ms. Benefield, today throughout this sentencing hearing, you and your attorney is going to be arguing for what we call a downward departure. And that is where you're going to be asking the court to go below the bottom of the guidelines or the lowest permissible sentence of 124.5 months. In order to do that, there's an evidentiary burden on the defense, and that is to prove by preponderance of the competent and substantial evidence that, one, you qualify for a downward departure, and two, that it's the most appropriate sentencing option and that the court should exercise its discretion to do so. So because you carry that evidentiary burden, that's why I generally start with the defense, then go to the state, and then come back to the defense. It's maybe the same or different as other judges do it, but if you want to do that, that's how I normally do it. If you prefer to do it the traditional way, I'll do it that way. Mr. Taylor?
I'm fine proceeding as the court suggests.
All right, sir. And then, of course, the closing, opening statements and closing arguments are all the same. All right.
Yes, sir. I assume we will handle the departure aspect first, and then I will go into my court.
Absolutely. Before we get started, I would imagine that there's going to be a number of folks who are going to make statements today, either pursuant to Marcy's Law or victim impact. And certainly this is not a capital case, but as if you've done a sentencing in front of me, you know that I generally follow the dictates of 921-141 and 921-143 on what's appropriate and permissible as the scope and nature of victim impact statements. State, have you had a chance to speak with the folks who are going to talk today and let them know that information?
Yes.
All right. And I don't know, Mr. Taylor, if how many people are going to speak today, or if anybody's going to speak. Certainly I received the stack of letters as part of the sentencing memo. If anybody's going to speak today, were you able to speak with them about the nature and scope of a statement to be made?
We're only going to have one witness, rder, and it goes to the departure.
All right, fair enough.
She's only
All
been
right,
in
with
jail.
that said,
She's only been in jail since her conviction, which was only about a little over a month ago. It's because she was out on bail.
Mr. Taylor, would you like to make any sort of opening statement? Or I'm going to address you mostly, Mr. Taylor, but if Mr. Pinnell, if you're handling part of it, please feel free to let me know. Or would you like to make any sort of opening?
Not necessary.
All right. State? Okay, then I'm ready for the presentation of evidence. Mr. Taylor.
We call Barbara Russell. Your Honor.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
Morning, ma'am. As you've heard me say multiple times before, just get about 12 to 15 inches from the microphone. It does adjust up, down, left, right. If you just speak in a loud, clear voice, we'll be able to hear everything.
Good morning. Would you tell us your full name
Barbara J. Russell.
and tell us a little bit about your education?
I have a master's degree in clinical social work. I have a doctorate in clinical psychology.
And the current position that you hold employment-wise?
I am self-employed. I have a clinical and forensic mental health practice
How long have you had such a practice?
for about 15 years.
Would it be correct in addressing you as Dr. Russell?
Yes, certainly.
All right, Dr. Russell, have you appeared before in the courts of the state of Florida and been recognized as an expert?
Yes.
Can you give us an idea of approximately how many occasions?
Typically, I testify in court as an expert in the state of Florida about 3 times a month for the last
And
8 or 9 years.
have you, in that capacity, appeared in the courts of Manatee County on a regular basis?
Yes, sir.
Specifically, have you appeared before Judge White in previous proceedings as an expert on mental health?
Yes, sir.
I want to ask you, Dr. Russell, amongst your other specialties, are you qualified to diagnose and treat PTSD?
Yes, it's one of my specialties in both my clinical and forensic practice.
All right, would you tell us what PTSD stands for?
Post-traumatic stress disorder.
And are you also qualified, in addition to PTSD, Dr. Russell, to treat domestic violence and abuse?
Yes.
Can you give us an idea of your experience in the domestic violence area on behalf of both abusers and abused?
I'm a nationally certified domestic violence clinical specialist. I have treated victims since early 1990 in various outpatient services, providing support groups, individual counseling. I have, for Circuit 12, provided court-ordered domestic violence intervention classes for offenders for about 8 years.
Right, and among other instances, have you been involved with the Batters intervention program as well?
Yes.
I want to ask you a few questions about Douglas Benefield. Did you have an opportunity in your capacity as a psychologist to interview him?
Yes.
Do you recall approximately when that would have been?
That would have been in April of 2020.
And approximately how long did that interview last?
He spoke with me for about 90 minutes.
Were you satisfied during the course of that interview that you had sufficient time to render a diagnosis of Mr. Benefield's personality?
Between that interview and also the collateral data, the documentation that I viewed, yes, very much so.
Would you tell us what that diagnosis was and your basis for it?
Douglas Benefield exhibited criteria that met the diagnostic categories of narcissistic and antisocial personality disorder.
And how, if at all, would that fold itself into being a potential abuser?
Well, the as well as the narcissistic components, he had little to no empathy. He really lacked the capacity to take responsibility for his behavior. He had a desire to be admired, to have constant attention. He felt very entitled and demanding to the attention and admiration of other people, whether or not he did anything to deserve it. And he had little regard for the rights of other people.
Are you familiar?
Correct me if I'm wrong, but didn't Ashley move in with this Barbara Russell for a little while at some point? I seem to remember that. And then they became friends. And I didn't realize she had also interviewed Doug.
Dr. Russell with Ashley Benefield.
Yes.
Do you have an opinion as to whether or not Ashley Benefield, as she sits here today before you, is currently suffering from any specific condition?
Yes.
Would you tell us what that is?
Ashley is suffering from post-traumatic stress.
And are you able to give us some insight into the basis that caused that syndrome that she suffers from?
It's really been caused by complex trauma. The root cause all comes down to the abusive relationship with Douglas Benefield. From the time the abuse began in their marriage up until the incident of the attack that led to the shooting on September 27th, there have been multiple situations that have severely distressed and traumatized her.
So I want to ask you a couple of questions about post-traumatic stress syndrome. And I'll use as an example the soldier that comes home from combat. Is there anything about this syndrome that requires or necessitates an instant response to stimuli immediately after the traumatic event? Or is that liable to happen at any time over the spectrum of conditions and circumstances that that individual may experience?
Symptoms can be delayed onset. So somebody can experience a severe trauma in January and perhaps not exhibit any kind of reactivity to stimuli that reminds them of that, or any emotional distress for days, weeks, months, even years later. So it's not unusual to see in November somebody have a problem, or even again years later. Delayed onset's common.
So again, using this hypothetical soldier as an example, 3 months after they return home following combat duty, they may not respond to any stimuli, but you're telling us as long as 18 months, 2 years later, when a spoon happens to fall into the garbage disposal and makes a clattering noise and they dive onto the floor, that would not be unusual.
No, it would not be.
Are you familiar, Dr. Russell, with the facts of this case and the circumstances surrounding the shooting?
Yes.
Do you have an opinion as to whether or not Douglas Benefield's conduct contributed to his death?
Absolutely.
Objection, improper opinion.
Overruled.
Yes, absolutely.
Take that, evil
And
stepsister
how so?
number one.
Douglas Benefield had a history of violent behavior. Douglas had been threatening Ashley, becoming increasingly aggressive in the weeks and days leading up to the shooting. He had been making verbal threats to her life. He was in her home. He was refusing to leave her home. He was acting in a manner very typical of Doug, only exacerbated at that time. He behaved in a manner that made her feel as though her life was in danger, that she was at serious risk of being killed or being seriously hurt.
Did there come a time, Dr.
Just so you know, Genergy says hopefully there were some letters or something given to the judge on behalf of Ashley's innocence. So many of you wrote letters to the court. They're part of the court file. So many people sent emails to Neil Taylor that were part of his sentencing memorandum. So yeah, a lot of you guys did. So good on you for getting involved and speaking your truth and sending your thoughts to the judge. Because last time Jules was in court with Neil Taylor, she had a conversation with him, and he said, she said, "What can people do if they want to help?" And he said, "You can write letters to the court," and they're heart-wrenching, a lot of them. So, prayers up for all of you who wrote letters to the court. That was good on you.
Russell, when you were approached by representatives of the Manatee County Sheriff's Office who asked that specific question,
Yes.
did you respond to them with basically the information you've given us here today?
Yes.
Tell us about whether or not you have formed an opinion as to Miss Benefield's psychological state at the time of this incident.
At the time of the incident, she was acting under extreme duress. She was in full survival mode, fully believing that her life was in danger. She was responding with an effort to stay alive. There's a process that happens in the human mind when we feel that our lives are in danger. We have to make survival decisions, and these decisions are made in fractions of seconds. Even outside our conscious awareness, we're assessing the situation, assessing our capacity to escape, assessing our capacity to fight back. And people make decisions based on what their survival brain, as I call it, tells them is going to keep them alive. She was doing what was biologically natural in a situation where somebody would feel that their life was in danger. And this was also compounded by the weeks, months, years of knowing Douglas Benefield to be violent and being afraid of him.
Did you, Dr. Russell, have any opportunities to actually observe Ashley Benefield's reaction around males and the manifestation of this post-traumatic stress syndrome and her comfort level?
Yes.
Tell us about it.
In the weeks, really the early months following the shooting, when Ashley was staying at my home, I would notice in particular, she would frequently apologize for things that didn't require an apology. She especially did that around my husband. If she was in the kitchen making a protein shake in the morning and he came in to make coffee, she always felt like she was in the way. She was always very quick to say she was sorry, to kind of flinch or pull back in a manner that was just completely appeared to be unnecessary based on the situation. You know, there was never any indication from him that she was being bothersome in any way, but she had an expectation that she was going to get yelled at or that somebody was going to be mad at her. I had noticed another occasion. My son had stopped by our house in the evening. It was dark unexpectedly. She looked out the window and saw a male figure approaching, and she came screaming through the house saying, "Someone's here, someone's approaching the house." She was very hyper aroused and reactive to situations, particularly with men.
Your Honor, I don't believe I have any further questions for Dr. Russell.
Cross?
Are you familiar with something called histrionic personality disorder?
Yes.
Can you explain what that is?
Histrionic personality disorder is a pervasive pattern of a person being very melodramatic to gain attention.
And are you aware that the defendant in this case has been diagnosed with that?
I'm aware that that's a false diagnosis, but yes,
So in your
Take
opinion, it's
that.
a false diagnosis? But you-
absolutely. Women who've been victimized by domestic.
I didn't ask a question.
Oh, excuse me.
Your-
Excuse me. She's Dr. Russell.
Let her finish.
Good. Clap
Women
back
who
at evil
victimize-
stepsister number one.
Women who have experienced victimization of intimate partner violence are often mischaracterized as being histrionic when the individual assessing them does not have a proper understanding or a complete picture of what has been going on in their lives.
And according to your beliefs, you believe that you do have that background and you are able to diagnose it quickly.
Absolutely.
And would you consider yourself unbiased when it comes to Ashley Benefield and Doug Benefield?
Absolutely.
Okay. So after you had your initial evaluation with Ashley Benefield, that was in, I think, April of 2020,
Correct.
you continued contact with her
Correct.
and she had your phone number
Of course, all of my clients have my phone number.
and she would call you on a regular basis.
She would call me on a regular basis to update me on what was going on in her situation, per my instruction, as there was potentially an upcoming court hearing regarding her situation.
And she would copy you on emails to her attorney.
I don't know. I don't recall that.
There were several emails that were sent to her family law attorney that had you CC on them.
Okay.
Would you agree with that?
That's a real possibility.
So as a therapist, is it normal to have a client CC you on their correspondence with their attorneys?
Yes, if I'm involved in a capacity where I could be testifying at a family law hearing or at an injunction hearing. That's very typical.
Okay. So several weeks, I suppose, after this homicide, she moved into your house.
Yes,
And your house, she lived with you, your husband, and your daughter.
correct.
And she lived there approximately a total of 8 months.
Approximately, yes.
And the night that the shooting occurred, you were called on the phone.
I was called by her attorney, yes.
Okay. And you showed up to the house where the murder happened.
Where the shooting happened, yes.
And that's a normal part of being a therapist. You show up at somebody's house when there's been a crime.
I have shown up at people's houses, at their place of employment, at a hospital emergency room. Crisis intervention is very much a part of being a mental health professional.
And
I showed up where the shooting happened. I love how she corrected her. Murder, shooting. I don't know. A part of me wants to see the evil stepsister examining her. A part of me does. It says it's too early, but maybe the camera will show her at some point. We'll see.
you know about the demonstrators that were out in front of the courthouse on numerous occasions during this case, correct?
Yes,
Holding signs, free Ashley.
yes, that's the Community Defense Committee called We Stand with Ashley. I'm familiar with that.
On numerous occasions, you were also out there holding signs
Yes,
and marching with this group.
yes,
And you still consider yourself unbiased.
absolutely. It's part of my ethical obligation as a licensed clinical social worker to be involved in situations that involve injustice.
Good for her. Good for her. People shouldn't stand up against injustice. Scott McGinnis, how do you feel about that? That's what this prosecutor wants you to believe. There was another prosecutor that we saw recently who was so different in their demeanor, the way they treated the defendant who had been in a similar situation. And right now, we've covered so many trials recently, I can't recall who it was. Remind me. And I said, oh, there's Jules right there on the left. And I said, if this prosecutor was in charge of Ashley Benefield, it would have been a totally different trial.
Now, you said that you were able to diagnose Doug Benefield after a 90-minute phone conversation and I believe you said collateral documentation.
Yes,
And a lot of that collateral documentation a lot of it included the paperwork for these injunctions that Ashley Benefield was trying to get against Doug Benefield, correct?
what do you mean by the paperwork?
The recitation of what Ashley said Doug had done and the things that she was trying to tell the court that Doug had done, trying to get the injunction.
No, that had nothing to do with my forming my opinion. In fact, the documents that I looked at that formed my clinical opinion of Douglas Benefield were mostly things that he documented, that he wrote, that he did. It was based on his behavior, not what somebody else says about him.
But it did include what Ashley Benefield said about him.
Not the documentation.
Good morning, Kurt. Kurt, I'm not in the mood for it today, Kurt. If you're gonna come in here and rile up my chat and make fun of Ashley, please just go to your own channel and do it respectfully, because I'm really, really not in the mood for it today, and neither is my chat. So please, I would never do that to your channel. I would never come into your channel and try and rile up your chat and mock a defendant who happens to be, in my opinion, the victim of domestic violence. I know that you think she's a liar and you have mocked her relentlessly and her testimony on your channel. So I'm going to respectfully ask you you can go to your channel and do that, but I'm not going to, the poking and prodding today in this chat I'm already on my last nerve and it's just not going to work for me. It's just not. And respectfully, I'm going to tell you that if you have never known anyone who's the victim of domestic violence and you have never known any survivors of domestic violence, you are a very, very lucky man. And I ask you, and I don't even need you to answer this, it's a rhetorical question. How would you expect a victim of domestic violence, stalking, coercive control, and emotional abuse to behave? What would be an acceptable, believable type of demeanor for you to believe that? And it just makes me think, based on how you handled this case on your own channel, you've never experienced it, you don't know anything about it, and you're very, very lucky. Consider yourself lucky. And that's all I'm going to say about it for now.
That I formed my opinion about him. Absolutely not.
Are you saying that what Ashley Benefield told you had nothing to do with your opinion?
My opinion in what was going on with him clinically had to do with the words that came out of his mouth as he talked to me for 90 minutes and the various correspondence and documentation that came from him, his emails to other people, things that he had documented, things that he told me that he did.
Okay, so after this evaluation and right before the time of the shooting, you said, I believe, that Doug was increasingly violent and it was becoming more dire, right?
Yes,
And you knew this because Ashley's telling you.
yes.
You didn't witness this for yourself.
No, I did. The only thing I witnessed were some of the text messages that he was sending her.
Okay, but you never saw any of the other evidence that he was becoming increasingly violent.
No, it was what she was reporting to me that he was saying and the messages that she was forwarding, some of which were quite threatening in nature.
I have no further questions. Thank you.
Redirect?
No, sir.
All right. Thank you very much, ma'am.
Thank you, Judge White.
All right. Did you have anybody else that either had testimony or wanted to make statements?
Statement by me, no further.
Oh, just closing?
Thank you, Dr. Russell.
Just closing?
As to the departure issue.
Yes, sir. All right. State, did you have any victim impact statements, any letters, anything that you wanted me to consider?
Yes, I have several people here that would like to speak, if now is the time.
Yes.
Your
I would
Honor, I'm
like-
sorry.
Yeah.
I want to just make sure the court didn't misunderstand. I did want to make a statement about the departure issue consistent with the testimony that the court just heard from.
Okay. Yeah. What I meant is I normally let the defense go first. So if there's any witnesses you want to put on in support of downward departures, any evidence you want to introduce
Okay.
in support of downward departures, anything you want to have me hear about sentencing, I want to hear all of that. And then I'm going to go to the state and I'm going to hear any evidence they want to present, testimony they want to present, victim impact statements they want to present. I do it globally.
Okay, so you want the whole shebang now?
Yes, exactly.
All right, fine. I'm ready.
Oh, okay. All right.
So let me.
Well, hold on. Let me make sure we need to be on the same page.
Yeah.
At this point, I'm still in the evidentiary portion. So if there's anybody else, if there's any other letters, cards, statements, other information you want me to consider, if there's any statements that any witnesses want to make here in open court in support of Ms. Benefield, I'll be happy to hear all of that. If it's argument in favor of the downward departure, I will hear that after I hear from the state and their witnesses.
Okay, and that was my initial understanding. Then once I give that, I will then complete my remarks as to sentencing.
Absolutely.
Okay,
Once we finish with the evidentiary portion, then I'm going to go closing, closing, closing.
understood. Thank you, Judge.
Yes, sir. Absolutely. All right, state.
So the first person, Judge, is Dave Benefield, who is Doug Benefield's brother. Thank you.
And I am going to have them sworn in.
I'm sorry.
Assholes like this are what makes this a disgusting community. You see this? Karen Reed, this is a disgusting troll, disgusting person, and this is what they do. This is what these people do. It's disgusting. And if you think I'm going to sit here and not call these people out and just, let it go, I'm not. Not. Goodbye.
Even if it's a statement, they'll be sworn in.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
All right, sir, if you could please state your full name for the record and then tell me what you want the court to know.
I'm David King Benefield, and I'm just wanting to provide a victim impact statement.
Yes, sir.
Thank you. I want to thank you for your excellent and just governance as you presided over this trial. Throughout this entire tragedy, I witnessed the steady progress of the due process of law that is meant to be at the heart of our country's justice system. To you, to Manatee County, to the entire Sheriff's Department, and to the state's prosecution team, I offer my deepest and most heartfelt appreciation. It is impossible to convey the depth of loss and grief that I feel daily at the death of my brother, Doug Benefield. On Monday morning, September 28th, 2020, Eva Benefield, my 19-year-old niece, called. She worried that she had not heard from her dad. He was not answering calls, which was very out of character for him. And soon after, I received a phone call that my brother was dead. On a call that included my cousin, Tommy Benefield, and Doug's family law attorney, Stephanie Murphy, we added to Eva to the call. Eva immediately asked what was up with her dad. I was in a state of disbelief and shock. I couldn't get the words out of my mouth. Before I could muster up the words to answer her, Eva exclaimed, "She killed him, didn't she?" The next couple of days are a blur as we spent time processing Doug's life, his death, and how to respond. Tommy and I picked up the U-Haul with Doug's belongings from Alicia's house, consolidated his few remaining belongings at his apartment in Bradenton, found where Sully had been boarded up for their planned move, then headed to South Carolina to meet up with Eva and to meet her needs. There were decisions to be made, belongings to consolidate, bills to be paid, and now the unthinkable decisions about investigations, communication with family and friends, autopsies, and the unfathomable what to do with Doug's body. Doug's body was still in Florida following an expedient autopsy. I just had to see him before he was cremated. I struggled to believe it, and I needed to see him. Up until that point, I had not cried. I was numb. Tommy and I went into the office of the crematorium while they brought Doug's body out. As I looked at him through a stained glass window, I began to weep, and I could not stop. As we got into the car, my weeping turned into loud wails. Tommy sat with me in the car while I wept and wailed uncontrollably. I have never experienced anything like that kind of grief and emotional pain. As I sat there, I had one of the most profound moments of my life. I trusted Jesus Christ as my Savior in 1985. I was living with my brother, Doug, while we both attended Texas A&M University. We had heard that our Uncle Doug, a test pilot and a hero to all of us, had been killed in a B-1 bomber crash. My brother Doug was named after him. Following Uncle Doug's death, my brother played an instrumental role in leading me to Christ. He witnessed the immediate change in my life. I dropped out of my fraternity. I spent hours reading the Bible and learning to pray. Jesus captivated my heart, and the old destructive habits just fell away. Depression left and joy came in. Where I had felt so lost, I finally had a direction for my life. Doug and I shared our faith journeys from that time in college until his death. As I sat in the car at the crematorium, wailing and gasping for air, I did what I had learned to do all those years ago with Doug. I prayed. My prayers were my thoughts screamed to God as loud as I could think in the midst of my uncontrollable crying. I felt the strong and clear answers of the Lord with each prayer I prayed. I asked God, why do I hurt so bad? God responded, because you loved him so much. Why did I love him so much? God's response was a series of images and memories that came flooding back in rapid succession. I remembered him letting go of the sissy bar on my first bike ride without training wheels and laughing as he shouted, "You can do it. Just keep pedaling." I remembered his encouragement at my first high school wrestling match. He was a very successful athlete and was always a state contender in wrestling. I was hyperventilating at my first match, and he was there to encourage me and help me overcome my fears. I remembered him taking me to a New Year's Eve jazz concert in Austin, Texas, during my first year in college. He knew I didn't have the money, and he paid for everything. I remembered even the little things that he made so special on that trip, like my first bagel covered with cream cheese and jelly when I didn't even know what a bagel was. To this day, every time I eat a bagel and cover it with cream cheese and jelly, I think of him. I remember his designer shirts that he let me wear, his coaching comments after my first fraternity meeting as president, the bedroom he built for me in a closet in our condo at Texas A&M, him gently but firmly correcting me after breaking his prized car when I took it out for a midnight joyride. And I remember my first cup of coffee in college that he made for me, and on and on. While these images were flashing through my mind, I heard the Lord impress me with this thought: you shared so many of your firsts with him. And the conversations with the Lord went on for quite some time. Why do we grieve with such pain? It is because of the glorious privilege God gives us to love deeply. I lost my dad to cancer at 12 years old, and my mom several years prior to Doug's death, but nothing hit me like this. God blessed me with two great brothers, and Doug, 2 years older than me, was such a gift to me. He was truly a hero in my life. Every day, I feel a kick in the gut from the loss of my brother Doug. I have spent hundreds of hours going through his well-kept records, literally tens of thousands of pictures of Ashley and Emerson, emails and texts, as I have ordered his affairs and tried to find anything that would explain what happened or that corroborated Ashley's version of the events. Rather, what I have found in his journals, his extensive emails, and meticulous records was a man with his heart set on loving his family well at all costs. I grieved Doug's loss so much because I loved him so much. He was strong, but he never used his strength to hurt people. He used it to serve and to love and help people. Doug made life so much richer. He had so many unique facets. He was an amazing artist. He was a defender of the weak, a visionary, a strength that would comfort you, not concern you, a laugh that made everything seem okay, and a way of including you that made you feel deeply loved and appreciated. He generously shared his discoveries of the beauty of life. When I was with him, everything seemed so much more exciting and hopeful. His friendship humbled me. His giftedness amazed me. His kindness comforted me. His strength strengthened me, and his passion for life inspired me. Doug was patient, almost to a fault. He hoped and he trusted deeply in the Lord with an unshakable optimism. He graciously endured so much suffering on behalf of the others, as was witnessed in his astounding patience with Ashley. He genuinely believed the best about others. This can come across as being naive or gullible, and in our weakness, that is certainly a danger. This can also make you an easy target for people, but it is truly a great way to live. I will never forget talking to Doug on the phone the first time I heard about his relationship with Ashley and the hope he had for their future. He eventually told me of his hopes for their marriage, their daughter, and all the endeavors they dreamed of in the future. I could not have imagined a more horrific ending to their story. I knew my brother intimately. Doug was absolutely not the monster Ashley alleged him to be. He was the complete opposite of what the defense presented. The primary evidence against Doug was his sworn testimony in family court, where he admitted to actions he deeply regretted that occurred on a single day, 3.5 years before Ashley killed him. The
I'm
defense
sorry. Did
presented a
he
slander.
shoot the gun into the wall and throw the gun into the wall, punch the dog unconscious, and throw the cat down the stairs all on the same day? Were all those things on the same day? And if he did them 3.5 years ago, and brother of Doug, if that's the only stuff that you know about, does that mean that's the only stuff that happened? And does that mean he wasn't capable of much more? Okay. He's allowed to say his piece and he lost his brother, so I'm going to show him that grace. But I respectfully say that just because those are the only things you know about doesn't mean that those are the only things that happened.
Campaign based upon gross exaggerations of Doug's own testimony and unverified allegations from Ashley. Doug patiently endured Ashley's verbal, emotional, and legal abuse for over 3 years and was still willing to reconcile with her, even serving her up until the time of his death. The month before Doug was killed, I spent 4 days with him in Mount Pleasant, South Carolina. He expressed to me his desire to help bring healing to Ashley and her mother from the trauma that they had experienced in the past. Doug realized he might not be able to salvage the marriage. He was resigned to being a single father and working with Ashley to care for Emerson. He was not angry or bitter, but filled with mercy and resolve to make the best of the situation. That was the brother I knew. His lover and his love and compassion for his family was unshakable. Ashley, I want you to know that I forgive you. You have caused me the greatest loss that I have ever experienced, one that almost daily causes me to completely stop what I am doing and weep from the overwhelming loss I feel. Doug touched every part of my life, and I can't process this senseless tragedy. But as Christ has forgiven me for my wrongs, I also forgive you. I do not hate you. I grieve for what your actions have and will cost you. It is again the exact opposite of what Doug sought for you and for Emerson when I think of you. I pray for your healing, the healing of your family, and for God's grace over Emerson as she grows. This is the very same thing that Doug told me was his desire for you 7 weeks before his death. Little did you know that the man that you sought so aggressively to get out of your life was a gift to you who had counted the cost to love you no matter what the cost, even his life. I found out after his death that there were many people who strongly encouraged him to leave you, even some who expressed concern for his life. But he would not give up on you. Ashley,
What he would not give up is control over her. Contrast this victim impact statement with the one we watched yesterday in the Jamie Lee Komorowski plea, guilty plea, wherein the biological father of the victim, Samantha Miller, got up and said through tears, I hate you. I hate everything about you. And when you get to hell, Jamie, I will open the door for you.
Doug's love was but a fraction of the love that God has for you. And I pray that you will experience God's forgiveness and mercy that only comes by knowing Jesus Christ and his cross and truly believing in him.
All right, thank you. State.
Next, we have Wes Benefield.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, sir, if you could please give me your name and then tell me what you want the court to know.
Yes, sir. My name is John Wesley Benefield Jr., Doug Benefield's older brother.
Yes, sir.
Thank you, Your Honor, for allowing the Benefield family to be heard. I ask the court to give Ashley Benefield the longest possible sentence for the egregious cold-blooded murder of her brother Douglas Glass Benefield. Doug has always been a man of faith, loved his family, loved this country, and his friends. The Benefield family has had a very long history for many generations of protecting this country, protecting others, helping others. Doug was a naval aviator after graduating from Texas A&M. Went on to do great things in life. Doug has a beautiful, smart daughter, Eva Benefield, who does not have a father anymore. Unfortunately, Eva's mom, Renee, passed away a number of years ago due to health issues. We all miss Renee, a wonderful wife, mother, and person. Ashley Benefield had an opportunity to make a great marriage, a partnership with Doug, be a great stepmom to Eva. We all know now what Ashley has done by murdering Doug in cold blood. Ashley doesn't care. She didn't care about Doug. She did not care about Eva. Ashley treated Eva horribly while Doug and Ashley were under the same roof in the beginning of their marriage. When Ashley had Emerson, their daughter, Ashley did not even tell Doug that she was born. As we found out in the jury trial, Ashley did not even recognize Doug as the father on the birth certificate. That's my understanding.
Judge, excuse me, I apologize for interrupting. I don't think attacking the defendant is part of a victim impact statement, so I argue this, ask the witness to move on to a different part of the statement.
I'll sustain.
Ashley treated Eva horribly.
In case you couldn't hear what he said, I said, I don't think attacking is part of a victim impact statement. I would ask that you stop or ask him to stop. And the judge said, no, it was sustained. And here, let me take this banner down for a second. Stephanie Murphy, lower left-hand corner of your screen. Remember Doug Benefield's attorney or divorce lawyer that went with him for the exchange and had a lot of testimony. And here's, I don't know why evil stepsister number one feels like she needs to stand over this man while he reads his statement. That's a little bizarre. We didn't see that during any of the victim impact statements yesterday when we watched Jamie Lee Komorowski's plea and victim impact statements. It was the victim's advocate that was standing next to them, wiping tears from her own face and consoling them. I don't know why she's standing here, but I think it's a little bit unusual.
While Doug and Ashley were under the same roof in the beginning of their marriage. Here.
Yeah.
The Benefield family has always been.
Why is she pointing to his paper? Did she script this for him? Look at them. Watch this.
Ashley treated Eva horribly while Doug and Ashley were under the same roof in the beginning of their marriage.
Like she's telling him where to go. Okay, this is weird.
Here. Yeah. The Benefield family has always been a very close family. We always had a great time together when we were all able to get together. We would catch up, have great meals together. We have a great God-loving family. Now we do not have Doug anymore. Eva does not have a dad anymore, or a loving mother, Renee. I'm retired law enforcement, retired deputy, Brazoria County Consul's Office, Texas. The South.
Okay, got it. So it looked like she had approved his statement initially, and then when the judge sustained that objection and said, no, you can't bash her, she's just guiding him where to read from. Thank you for clarifying that during my very tired brain this morning.
Outside of Houston. As the court, the sheriff's office, and the state attorney's office have seen and dealt with animals that murder, steal, rape, home invasions, pedophiles, so have I. When you look at these egregious offenders, once they get out of incarceration, many of them go back to the streets and continue to commit the same type of aggravated offenses until they're caught again. During the jury trial, Ashley would occasionally look at me and my family with this arrogant smirk, showing that she...
Again,
Sustained.
arrogant smirk. Stop. You're not here to bash the defendant. Where were you during
In
Doug's
conclusion,
life?
I respectfully ask for the full sentence of incarceration due to the cold-blooded murder of Doug Benefield. I'll give you one last example of how we know Ashley doesn't care about Doug and the Benefield family.
Sustained.
I'm sorry, Madam Prosecutor. If you're standing right next to him, why are you not stopping him from saying this? You stopped him from saying a bunch of other stuff that was derogatory, hate-filled, and attacking her. I'm sorry that he feels that way, but this is not appropriate.
Okay. Your Honor, thank you again for allowing us to be heard.
Thank you, sir. State.
Tommy Benefield.
Comes cousin Tommy.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, sir, if you could give me your full name and then tell me what you want the court to know.
Yes, sir. Tommy Douglas Benefield, Jr. I had one younger brother, but my relationship with Douglas Benefield was even closer than that. Douglas was named after my father, a very famous Naval Air Force aviator, test pilot, combat veteran. And Doug followed in the footsteps of my father, much the way many of our Benefield family did. We heard from the expert who spent 90 minutes with Doug, but I spent 59 years with Doug. We knew him much better than any 90-minute expert. Before Ashley was born, Doug was a graduate of Texas A&M in biology with scores high enough to get into medical school. Because Doug was raised in a very middle-class family, did not have the money or scholarships like today to go to medical school, he chose to go into the Navy program that I helped sponsor him into, which led to him spending 3 combat tours off of aircraft carriers in the Western Pacific and in the Middle East. Doug was both a naval flight officer, meaning that he was a warfare officer, aviation warfare officer, and he also flew the airplane, which was unusual at that time, but something that he could do like many other things. In 1992, he went through 1-year training as an intelligence officer for the U.S. Navy and eventually for the Defense Intelligence Agency. During all those trials and tests in the Navy and in the intelligence plans and purposes, Doug was always tested to the highest levels to make sure that he could withstand the stress of combat, the stress of life, and separate those two things well. After becoming an intelligence officer, his other job, his public job, was as a mine warfare officer and instructor at the Navy's Mine Warfare School in Charleston, South Carolina. He did that for 3 years. After that, he went 3 years for the Defense Intelligence Agency as an analyst and a technical operations expert. In 1999, he left active service but stayed in the reserves and continued his service to this country for almost 20 years. In 2000, he married Renee, his longtime amazing wife. In 2001, their daughter Eva was born, who's here today, and you'll hear from after me. 2015, after a long run, Renee passed away, despite what the defense has alleged, of a heart attack under natural conditions. Doug became a single parent, like I was many times in my life, unfortunately. And in 2016, he met Ashley. I met Ashley April of 2017. I remember the first encounter. I remember being at the home at 701 Preservation Place. I remember the calm and comfort, the love between them at the time. But a few months later, Ashley separated from Doug under one purpose, saying that she was having trouble with her pregnancy, but with ulterior means. And that is the history that we know through this process. What we don't, most people know about Doug Benefield is when he was 12 years old in 1971, like Doug, who could figure out things that no one else could for this country, for the special operations warfare operators, for the emergency responders, Doug, Wes, and David's father figured out how to use microwave and laser systems to communicate and track space objects before anyone understood what that was capable of. That was 1971. Like Doug, was passed on to him one of Doug's current technologies that no one in the world could figure out but Doug. It's called transpositional modulation. It's a radio frequency waveform technology that offers dramatic bandwidth increases and novel security functions for existing wired and wireless networks. There's a multi-billion-dollar corporation founded on the fact that Doug Benefield could figure out how to make two signals go on.
Here's an interesting comment. So you're criticizing a dead man's brother's impact statement. I don't believe that I did that. That's disgusting, Melanie. You have no idea what really happened. Do you? You have zero idea who is the real abuser, so you champion in murder? What a bizarre comment. Everything about this is bizarre.
On the same frequency.
Maybe you should go over to Kurt's channel on civil law. He did go live. He said some stuff and then he quickly deleted it. So I don't know, you might feel more comfortable over there. What I'm pointing out is these people didn't know Doug. If you watched the trial, you would know that Tommy didn't even know that Doug married Ashley. I think he saw them exactly twice together. exactly twice. So just like you don't know what went on and I don't know what went on, neither does he. So there's that. Yeah, what did I say?
At the same time. That accomplishes what no one thought possible, the simultaneous transmission of two or more distinct data paths on a single carrier signal. Quantum physics in use on 5G networks all around this country today. He also founded the patents that would lead to secure data via quantum physics that encrypts swiftly and securely all data that's unhackable even in today's world. Right now, here's just some of the patents that are in use under Doug's name. Lighting control devices and methods. Task ambient heating and air conditioning systems for distributed space conditioning. Methods and systems for air quality analysis, diagnostics, and environmental controls. Heating and air conditioning fire suppression systems. And even the most craziest one of all is called free space optical transmission system for vehicle networking. The reason that our cars, more importantly, our special operators all around the world in the Western world can data transfer from sole operators behind enemy lines to their command and control is because Doug Benefield figured it out. John 10:10 says to us, the thief comes only to steal and destroy, as opposed to Christ, who's come that they may have life and live it to the full. I believe that the people who have supported Ashley have been deceived. They've had stolen from them their time and their effort. That
Judge, I'm going to object on the same basis. It's not a proper victim.
Sustained.
there's been no question in my mind or in this court under the stand your ground hearing, which was found that Ashley did not have a self-defense enough to reach that threshold, that she stole from Doug. There's no question that she killed Doug.
Judge, same objection. I'd ask the state to direct the witness to give appropriate victim impact.
His statement is supposed to be about his impact. The impact on him for Doug's death. He's not there. It's improper for him to start talking about how much he hates Ashley, his opinion of the stand your ground hearing, his opinion of the proceedings. It's about how the death of his cousin impacts him and how that should affect the judge in sentencing. And the objections to everything that he's saying, or many of the things that he's saying, have all been sustained so far.
I would disagree. It is allowed that the victim's family can make statements about the defendant. I understand if the defense is asking that they not, make broad
Characterizations and opinions about the crime, the defendant, and the appropriate sentence shall not be permitted as part of a victim impact evidence.
I'll take care of that, Your Honor. I'll
Yes,
make sure.
Thank you.
Thank you, Judge, for always having the law at the ready.
921.141 sub 8. How I started this sentencing hearing was
Oh, Madam Prosecutor, you're going to ask the judge to give you a citation? Listen to this. Where are you reading that from, Judge? Listen.
I understand if the defense is asking that they not, make broad
characterizations and opinions about the crime, the defendant, and the appropriate sentence shall not be permitted as part of a victim impact evidence.
I'll take care of that, Your Honor. I'll
Yes,
make sure.
Thank you.
And you're reading that from?
921.141 sub 8. How I started this sentencing hearing was, this is not a capital sentencing. However, when I do sentencings, I think those are good guidelines to use in formulating the nature and extent of a victim impact statement.
No problem,
Sure.
sir. I'll wrap it up and I'll be careful.
Sir, tell me everything you want to know The victim impact evidence is designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death.
Okay, I just want to point out that the judge is speaking and this prosecutor is whispering to her co-stepsister while he's speaking and making nasty faces, I think. Let's just take it back and see what faces she's making. So rude.
The victim impact evidence is designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death.
And
Yes,
she
sir. I
shakes
believe
her
I've
head.
done that so far, and I'll finish it with that, sir. What saddens me personally is the loss of Doug to our family, to Eva in particular, who has no parents, as she said and demonstrated. The worst part of it is that there's a 6-year-old that will grow up not knowing the man that we've known all of our lives. The loss to this country and to the Western world of the brain, the smarts, the ability to problem solve in a way no one thought possible, that all the engineers said couldn't happen, was something unique to Doug Benefield that was stolen from us, our family, his daughters, and the world. And I'm sorry that we're here, but that's the theft that's happened. That's the loss to this country that's so much greater than anything could possibly be replaced. I personally, our family asks for a minimum of 25 years and the maximum of possible of 30 years, Your Honor, due to the grievous loss of killing Doug Benefield by Ashley Benefield. Thank you,
sir.
Your Honor.
And I
All
believe
right, Steve?
lastly, we have Eva Benefield.
Do you solemnly swear or affirm the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
I think this goes without saying.
Oh, yes, ma'am, if you'd please introduce
But I'm going
yourself
to
to the
ask you to
court and tell me.
refrain from any nasty comments about Eva Benefield. Thank you.
What you want me to know.
I'm Eva Benefield, Doug's daughter. When my dad moved from Charleston to Florida, I was a little over 18 years old and preparing to go to college. He was on the road a lot, and I would occasionally see him when he passed through South Carolina on his way up north. Although I did not get to see him as much as I liked, he was always a text or a phone call away. After my mom died, my dad knew it was important for him to answer the phone as soon as he could. He was out of town when she passed, and I had been trying to call and text her after school for what felt like hours of waiting in the carpool pickup line. After finding her later that evening, any time my dad didn't answer, it sent me into a spiral. My brain automatically went to the worst possible outcome, thinking something terrible happened. My dad's colleagues can attest to the fact that even if he was in the most important meeting of his life, when I called, he would step out immediately and let me know that he was in a meeting and he would call me back as soon as possible. My dad usually woke up in the very early hours of the day. The first thing he sent me was always a Bible verse followed by "Good morning, pumpkin." This was his way of letting me know that when he was awake and he was available for me to call him when I woke up and tell him about the day I had ahead of me. The morning of September 28th, I woke up to no messages from my dad. I wasn't alarmed quite yet. Sometimes he rushed to the gym or had to immediately get to his computer for work. As the morning droned on, I anxiously awaited a phone call or a text message from him. Around lunchtime, I began Googling about traffic accidents in Sarasota, Florida. My friends told me, I told my friends I was worried, and they let me know I had nothing to worry about, that my anxiety-ridden brain was just flocking to the worst possible outcome. 9:24 a.m. Good morning. 10:42. Hello. 10:43. You're kind of scaring me. 11:20. You should definitely text me so I know you're okay. 11:48. I'm about to text Ashley. 11:49. Just kidding, I don't have her number. 12:03. This is freaking me out. 12:55. Please, please, please answer. 12:56. Great, now my texts aren't going through. 12:57. I hate this so much. It was about an hour later that I received a phone call from my uncles that my dad had been shot the night before. Is he okay? I asked. My uncle responded with a hesitant no. My next question before hanging up the phone was, she did it, didn't she?
Wait a second. Nobody notified her until the next day? What the what? Wasn't he DOA? Like he didn't survive at all in the hospital. Nobody contacted her until the next day, right? This is the first I'm hearing. That's heartbreaking. Right. Hold on. I got to rewind that a little bit.
Great, now my texts aren't going through. 12:57. I hate this so much. It was about an hour later that I received a phone call from my uncles that my dad had been shot the night before. Is he okay? I asked. My uncle responded with a hesitant no. My next question before hanging up the phone was, she did it, didn't she? Ashley, since the day you shot my father, I have only had one question to ask you. Why? Why did you end my dad's life knowing he was my only living parent and the only person I could confide in and count on for everything I needed as I turned into a young adult? Why did you willingly take away your daughter's father, knowing the consequences of your actions would leave her without either parent to help her navigate through her own life? You somehow managed to orphan not one, but two young girls. Unlike Emerson, I am fortunate enough to have known my dad for a full 19 years before you ended his life. He taught me how to paint. He attended every extracurricular activity I had. He took me to dinner on Valentine's Day. He drove almost an hour out of his way every day to drop coffee off in the school office for me and my friends. When he was in too much pain to surf with me, he would sit under an umbrella on the beach all day during the hottest months of the year. He would cut fresh flowers from the garden every morning before my mom woke up and left them on her bedside table. While I ran in the mornings before school, he cooked breakfast so it would be ready on the table when I got home. Every Saturday, we made oatmeal cookies together. Every Sunday, we would go to church and get a coffee after. When you moved into my childhood home, I watched my dad fix the door frame with a crack in it from where the neighbor had to knock the door down to get into the house after my mom died. I watched my dad paint over every memory in every corner of that house, change the furniture, rid the house of every bit of my mom that was left so you could enjoy life without remnants of my dad's late wife and soulmate. I had to come.
I mean, he's the one who did it, but she blames Ashley. She was young. I mean, I guess I understand that, but it's kind of on her father, isn't it? Removing every sign of her mom.
Come home from school to see you barely clothed, sitting on the countertops my mom used to cook our family dinner on. I had to live in a house stripped of memories I still cling to so I can remember the happy childhood my parents gave me. Not only did you make my home nothing more than a house with 4 empty walls and a roof while I was grieving the loss of my mother, you tried to bring my mother's sweet spirit into your soulless world by spreading lies that she was killed by my own dad. You got medical records pulled, and you were moments away from getting her removed from her own grave.
I apologize for interrupting. Same objection. I don't think the fact of the defendant is appropriate to make that statement.
Sustained.
When you left my dad the first time, I watched his face as he read the letter you left on the bed for him. The house was quiet that day, and while I felt sorry for my dad because I saw the pain in his eyes, I was secretly excited to have my dad back. Those few months that he received nothing but radio silence from you, I was able to finally regain the relationship we once had. Things finally felt normal again. Easter weekend of 2018, my dad insisted that I drove to Florida with him so I could enjoy Easter Sunday with my half-sister. The night before Easter, you and Alicia pulled me aside before dinner to try and convince me that my dad was a monster, that he killed my mother, that he was evil and I was unsafe. The next morning before you brought Emerson over to open Easter baskets, my dad could tell something was off.
Shut, same objection.
I can see two ways this could go. It could come back around. I don't know where it's going, though. I don't know what the next statements are. If the next statements contrast that with with evidence designed to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members, by the victim's death, then I'll overrule the objection. If not, I'll sustain.
While I feel deeply sorry for everyone who was affected by these last few hurricanes this year, they couldn't help but remind me of the time my dad drove 8 hours through a hurricane to come help you board the house you lived in at the time. My dad was the opposite of what you have attempted to portray him as. Doug Benefield was kind to a fault. He was smart, he was strong, and most importantly, he was generous. His generosity is what got him killed. December 2nd, 2014, 10 years ago yesterday, my dad was out of town when I found my mother dead on the floor at 14 years old. Her funeral was the first and only time I saw my dad cry. Not even a year later, he met you during what I imagined to be a very lonely part of his life. You decided to put on your biggest act of your career and pretend to be everything he needed to fill a void. I watched him.
Same objection. Again, apologize for interrupting.
And Judge, I think she can talk about her dad and how he took this in and was kind. Even
If that's where it's going, but as I've said multiple times, and as I'm pretty sure I confirmed before we started, that the state had gone over with its witnesses,
yes.
the nature and extent of an
I
appropriate
just have
victim
a
impact.
difference of opinion as to what they're allowed to say, Judge.
Well,
So it's
I'm
difficult
going
for
by
me
the
to-
Florida
courtroom.
law,
for death penalty cases.
and I said that it's appropriate. I think they're good guidelines.
Wow. She's arguing with the judge in open court
I
during
watched him
sentencing.
bend
Not
over
a good look.
backwards for your every need. For years, he gave you everything he had, time and time again, trying to show you, Emerson and Alicia, nothing but love. He wanted nothing more to show you what true acts of love are. You took advantage of his willingness to give, and he gave you his life. After my dad passed, there were a lot of sleepless nights contemplating if my life was even worth living. I had no financial help, no parental guidance, and no will to live. The idea of ending my own life was oddly gave me some sort of satisfaction knowing you would have to live the rest of yours with blood of 2 Benefields on your hands. Shortly after those dark days, I realized I would selfishly be doing my parents a disgrace to not live every day to its fullest as they had taught me before they passed. I also realized that not only would you not care if I was dead, it would probably be beneficial to you. I'm the only one who can speak truthfully on behalf of my father and fight for his justice. While the grief of my parents will always live within me, what hurts me the most is not the thought of not having my dad anymore, because I will always have him around in spirit as I continue to implement the lessons he taught me during my adult years. What breaks my heart the most is thinking about how he found you at such a vulnerable part of his life, gave you everything you asked for. After you shot him while he was unarmed, he laid there bleeding out, unable to speak or to breathe, completely helpless and dying alone.
All right, thank you, ma'am.
Thank you.
State, did you have any other victim impact statements?
No, Judge, that's it.
All right. Any other evidence that you were going to submit? Any letters, documents, anything?
No.
Okay. Rebuttal evidence or statements? Or just argument?
I have some more arguments.
Okay, so I'm going to consider the evidentiary portion closed. We're going to begin the closing arguments. And so we're going to go defense first, then I'll go to the state, then I'll come back to the defense for rebuttal.
Before addressing my closing remarks, I want to address the downward departure specifically and make 2 comments. One is to the victim's status. I want the court to recall the independent evidence that was adduced at trial, for the moment excluding Ms. Benefield's testimony. Specifically, Doug Benefield's admissions establishing a prior history of domestic violence. There's obviously a dispute, and it depends to a great extent through whose lens Doug Benefield is viewed. Perhaps the truth is best found in the testimony of independent witnesses, because family who loved Doug Benefield sees him in one light, and the independent witnesses see him in a different light. So we not only have the admissions that did not come into evidence at trial, but I know that the court is aware of, and of course, this being a sentencing hearing, the formal rules of evidence are not applicable. And in those admissions, Doug Benefield not only admitted to various acts of domestic violence, I don't think an act such as firing a firearm in the kitchen of a home into the ceiling, specifically acknowledging that you did it to intimidate your wife into stopping to speak, is the kind of act that one is able to say, gee, you know, in hindsight, I've thought about it and I was wrong. Forgive me. There are certain acts that manifest a much deeper problem. And those of us that are members of society who have never so much as contemplated such an act realize that it speaks to a much deeper problem. So we not only have Doug Benefield's admissions under oath of these various domestic violence incidents, but we have him violating the South Carolina court's domestic violence injunction, his efforts to purchase the house behind Ashley Benefield's while the domestic violence injunction was in full force and effect, placing a tracker on Miss Benefield's car, being caught by a neighbor at night lurking in the backyard, and the independent expert testimony from not only Dr. Jason Quintal, describing Doug Benefield as super controlling, a real alpha male, and intimidating, quote unquote, as well as Bruce Ferris, who said that Doug Benefield was a classic abuser who showed all the textbook characteristics. And then, of course, the text message from his deceased wife, Renee, clearly explaining about being physically abused on their honeymoon. I think that the facts establish, for purposes of a downward departure, Douglas Benefield's contribution to this incident and the threat that he posed to Ashley Benefield. And because of that, I believe that the defense has clearly met their burden by a preponderance of establishing that Doug Benefield was a willing participant in the conduct that led to the shooting. The second basis, Judge White, with respect to departure, would be the extreme duress that Ashley Benefield was under at the time of the shooting. The expert testimony the court heard from today from Dr. Barbara Russell speaks to that. And the only testimony that is in the record that actually was put forth to recount the events of that date was by Ashley Benefield. There is no other testimony. And in that testimony, she clearly recounted not only the body checks that Doug Benefield delivered to her that day, the cardboard box assault, the false imprisonment when she tried to leave the house, the slap. It was very clear from the letter that Ms. Benefield left for Doug Benefield that she feared for not only her own safety, but the safety of her unborn child. She articulated that quite clearly in a letter written 3 years before this incident. That's either an incredibly prescient false flag that was planted or the truth? The truth of a woman who was scared. The truth of a woman who, despite what the court has heard about Doug Benefield from the family who loved him, obviously had a much deeper problem. I believe that together with those incidents, Doug Benefield's admission and the confrontation on that day, Ashley Benefield was clearly, as Dr. Barbara Russell explained, acting under extreme duress. And I believe that the burden as to that basis for departure was carried as well. With respect to closing remarks on behalf of Ms. Benefield, Your Honor. I want to make it very, very clear that despite the exposure that Ms. Benefield faces to the court's potential sanction, she adamantly maintains her innocence, that she acted out of fear for her personal safety and shot Douglas Benefield in self-defense. The sound discretion of the trial court in ruling upon the admissibility of various evidence, that's the phrase that the appellate courts use to describe the authority of the trial judge, is the object of that discretion to ensure that evidence which comes before the jury is reliable and trustworthy? Or is that discretion designed to allow the trial court to manipulate the outcome of a trial to achieve a particular result? Jurors are told in every trial that there are two judges: the court, who is the judge of the facts of the law, and the jurors, who are the judges of the facts. But what if facts, essential facts, are kept from the jury? What if the court, rather than using its discretion to ensure the evidence is reliable and trustworthy, instead uses its discretion to undermine the effectiveness of the defense, to retard their efforts, to water down the impact of their position? Respectfully, that is precisely what we believe occurred here. Ms. Benefield was deprived of a fair trial, Judge White. Despite that, she was still acquitted of murder. Further, we believe that had the facts been put before the jury, Ms. Benefield would have been found not guilty. What then is our basis for that proposition? Let's start, if we can, with the court's order denying our stand your ground motion.
Judge, I'm going to object to going over the court's rulings being wrong. I don't really understand the significance of this in a sentencing. These are past orders and we don't need to rehash them. You disagree that they're correct.
All right, what's your objection? What, improper argument?
Improper argument.
Sir?
I believe, Your Honor, this is a sentencing under the rules of criminal procedure. We have an absolute right to address the court. I deliver my remarks not out of disrespect, but of counsel for a woman who faces 30 years in prison for a crime that she adamantly maintains she did not commit.
Overruled.
Thank you. In the court's order, the court stated that this was instead the culmination of a lengthy, concerted effort by the defendant to eliminate the victim from her life and the life of their child. When the defendant's efforts to enlist the assistance of law enforcement, child protective services, and the judicial system failed, she took matters into her own hands, as she told Dr. Broder she would. So what happens with that statement is that we take the deposition of Dr. Broder. And I asked Dr. Broder in that deposition, now that would make your statement incorrect, would it not? And I'm specifically referring to Dr. Broder's statement that Ashley told him she was going to have to take matters into her own hands, thereby insinuating she shot Doug. And Dr. Broder's response was, in terms of that quote from the report, yes. I then asked, so based on that, those would be your words, not Ms. Benefield's, correct? And Dr.
I just want to point out that these prosecutors have a little button on the microphone in front of them where they can mute themselves when they choose to whisper to each other or cough into the mic, and they choose not to mute themselves. So let that give you a little window into their souls.
Broder answered in the testimony, yes. Question, all right. And it referred, your comment referred to Ms. Benefield's decision to seek help from the Maryland authorities. Did it not? Answer, that was her plan, yes. What's troubling is that Dr. Broder's testimony at the Stand Your Ground hearing then was at best mistaken and at worst a false implication to mislead this court. And the court bought it because it said, just as she told Dr. Broder she would. So we felt that the Stand Your Ground decision was based upon a mistaken statement by Dr. Broder under the best of circumstances. Now, what are the other issues that we feel deprived Ms. Benefield of a fair trial and precluded her from putting her best case, her best defense before the jury? There were a number of evidentiary rulings that Your Honor made. Specifically, Detective Warren's conclusion that he reached less than 45 minutes after the dispatch call came to him about the shooting, that the matter was a murder as opposed to a homicide. The court may recall that the lieutenant in that department testified that you can't make a decision about a homicide immediately. It takes time. You must investigate it. They could have applied for the warrant. Detective Warren could have applied for the warrant and secured it just as well by submitting that the crime, the potential crime that occurred was a homicide. Instead, within 45 minutes, he described it as a murder. The significance of that is that it shows his state of mind and whether or not this was always an incident and a bias towards Doug Benefield that they embraced. Doug?
To answer Joanne's question here, she says, this statement by the defense attorney can't be helping, can it? Yes, it absolutely can. He's already made this motion on paper. He's looking for a downward departure from the sentencing guidelines, which is somewhere around a low of 10 years. And all these are all the reasons why he thinks that the judge should depart downward from the minimum, which I think he said was like 124.5 months. And so in a downward departure type argument, he's absolutely allowed to make this closing argument. And the prosecution was overruled when they tried to get him to stop talking about this stuff, and it absolutely can help. So it is done in some states. They allow it. Florida is one.
Was a man's man from everything that the court has heard from his family who loved him. He was very skilled at manipulation and was easily able to cuddle up with the detectives, and they liked him. And because they liked him, it influenced the objectivity of their approach to the case. We were never given the opportunity to establish that. Secondly, the email exchange between Detective Warren and Miss O'Donnell, where they discussed and participated in representing different facts for the purpose of securing an arrest warrant. Again, it went to their credibility. We were not entitled to get that in front of the jurors. The lead detective's perception, in addition to calling this a murder within 45 minutes, that, quote, all killings are murders and all who kill are murderers. This is the mentality of the lead homicide detective in the accusation against Ms. Benefield. We were precluded from demonstrating that before this jury to be able to argue with credibility that Ashley Benefield never had a chance. They decided, Detective Warren decided within 45 minutes this was a murder, and then he did everything from that point on to support his position. It went to the heart of this detective's credibility. The admissions by Douglas Benefield in his deposition of July 17, 2018, somehow the court concluded that that was not a statement against interest, which we bitterly disagreed with and still do. But more importantly, it was the integrity of the statement of the victim under oath that we were never able to put before this panel for them to make their own independent judgment. It's one thing for me on behalf of Ms. Benefield to be able to argue to the jurors that he made this statement. It's quite another thing for them to hear it out of his own mouth, and in particular, for them to hear that his explanation for it was that he blamed it on Ashley. This is classic abuser perception, that it was Ashley's fault because she would not stop speaking, and it was her fault that made him fire this gun into the ceiling of their home. It deprived the jury of clearly the most persuasive and compelling evidence that the defense could have put before them. That same strategy was employed by the court in keeping out the letter that Ashley Benefield wrote and left for Doug Benefield on September 17, 2018. I don't know that I've ever had an instance of a more specific state of mind exception to the hearsay rule than that letter. There is no way that anyone, I would submit, could articulate with the same decisive and persuasive influence on the jurors that that letter, seeing it, feeling it, reading it, would have accomplished had it gone to the jurors. In that letter, Miss Benefield not only stated how deathly afraid she was for her own life and the life of her child, but she also listed all the financial problems that beset them, and in particular Doug Benefield, which would have addressed the unspoken perception and knee-jerk reaction that constantly arises from the perception that Miss Benefield was a gold digger who married somebody who was only going to be able to provide for her. I think it would have been significant for the jurors to hear from Bruce Ferris that this perception of domestic violence and lack of appreciation for it infects our institutions as well as the courts themselves. And I think Bruce Ferris was extremely qualified to provide such testimony, given his background as an active deputy sheriff who worked and specialized in domestic violence and was in court time and time and time again.
I know that I'm wearing earbuds, so I can hear it super loud in my earbuds. I can hear them whispering. Can you guys hear it if you're not listening with earbuds, or is it just annoying the hell out of me only? Because they have a mute button and they should be using it.
We had an instance where both parties agreed and the court approved for a cutoff for motions. Despite the fact that we both agreed, we signed a written stipulation, both myself and Miss O'Donnell and the court. The state still moved for a Daubert hearing after the court suggested it, after the deadline for such motions was closed. The court allowed the state to do it, reopened it. We had the hearing. The court still allowed Bruce Ferris to testify. When the state sought to introduce the video of Douglas Benefield and Miss Benefield and Emerson Benefield and Alicia at the restaurant, upon the defense objection, the court, to the state's surprise, sustained the objection. The state, recognizing how critical that evidence was to their case, looked to the court for help, and it came in a suggestion from the court that perhaps they may try to introduce that evidence under the silent witness theory. Inexplicably, another piece of evidence that was kept from the jury was the DNA evidence. Despite having filed a notice of disclosure of intent to introduce business records declaration, the court prohibited us from introducing the DNA report, which showed that Douglas Benefield's DNA was in fact found on Ashley Benefield's arm and hand, which would have corroborated
Does
Ms.
that change
Benefield's testimony.
anyone's opinion? All those people in the chat who think that she was not in fear for her life, would it have changed your opinion to know that his DNA was on her arm and hand and they had not been living together? Let's listen to that again.
DNA report, which showed, prohibited us from introducing the DNA report, which showed that Douglas Benefield's DNA was in fact found on Ashley Benefield's arm and hand, which would have corroborated Miss Benefield's testimony that she initially tried to flee her home, only to have Douglas Benefield grab her, spin her around, put his own back to the door of the home, and refuse to allow her to leave. At trial, the court allowed substantial hearsay to come in through the testimony of Stephanie Murphy. We objected and asked for an instruction. The court agreed that an instruction, a limiting instruction, would be appropriate, yet the court never gave such an instruction. And the reason the court gave for not giving the instruction was that the state and the defense were unable to agree to the language. The court should have fashioned an instruction and given it. The court allowed Detective Christopher Gillum to testify to his various interactions with Ms. Benefield, and in particular, Ms. Benefield's response. Yet, Your Honor would not allow the defense to call Samara Sweet, who was the Assistant State Attorney for the Manatee County State Attorney's Office, assigned to the case that Detective Gillum testified about, to rebut what Detective Gillum said. Because Samantha Sweet would have said, when she left the office, she fully expected that case, specifically the violation of the South Carolina domestic violence injunction by Douglas Benefield, to be charged. Additionally, the court made some non-evidentiary decisions which we felt had a profound impact on retarding the effectiveness of the defense's case. The court actually quashed the defendant's subpoena to Judge Moreland's judicial assistant and forced the defense to pit Ms. Benefield's former family law attorney against the state's star witness and Doug Benefield's former family law attorney, Stephanie Murphy. We have a Sixth Amendment absolute constitutional right to compel the attendance of witnesses. On behalf of Ms. Benefield, using my judgment and my experience, I felt that Judge Moreland's JA had no dog in this fight. There was no one that would have been more credible to explain to the jurors that the state's theory, the entire theory of prosecution, that Ashley Benefield killed Douglas Benefield because the Broder report was scheduled to be released, was absolutely false, because the JA would have testified that that report was not set for release. There was no date that had been given for that release. Somehow the court decided that we, the defense, could establish that through a different witness rather than the JA. Respectfully, that is not Your Honor's decision. That was my decision, and it should have been honored, because as I stand here today, I felt and still feel that that would have been the most persuasive evidence to show the jury that Stephanie Murphy's testimony was not worthy of belief. The court allowed, in closing argument, the state to allege that Doug Benefield filed for sole custody of Eva Benefield on May 4th. And that's just factually inaccurate. The fact of the matter was it was Ashley Benefield who filed for sole custody of Eva Benefield. Yet our objection was overruled.
During
Or-
closing?
Sir?
During closing? You
Yes.
objected during closing?
Yes.
No.
Additionally,
Excuse me?
Wait, hold on.
Can you point to me in the transcript where that is?
Hold on. I got
I'm
to take
not-
this back because we're not talking about Eva Benefield. Aren't we talking about Emerson? Hold on a second. Emerson is the daughter that Ashley and Doug had together. Eva is the adult daughter from Doug's first marriage who spoke during the sentencing. So I just need to hear this again. I think he misspoke. He did misspeak. Okay. I'm not insane yet. Thanks. I'm just going to take it back.
out for sole custody, allowed in closing. The court allowed, in closing argument, the state to allege that Doug Benefield filed for sole custody of
I remember that.
Eva Benefield on May 4th.
It means Emerson.
And that's just factually inaccurate. The fact of the matter was it was Ashley Benefield who filed for sole custody of Eva Benefield. Yet our objection was overruled.
Did he object? I don't remember.
During
Or-
closing?
Honestly, I don't remember if he objected.
Sir?
During closing? You
Yes.
objected during closing?
Jamie, do you
Yes.
remember?
Additionally,
Excuse me? Can you point to me in the transcript where that is?
I'm not prepared to do that now, but as the court knows, the transcript is readily available. What the court did do, however, was despite the state arguing that Doug Benefield was not facing Ashley Benefield at the time of the shooting, even though that was what their own medical examiner testified to. When I characterize the state's argument as ridiculous, the court felt that was sufficient to sustain an objection. The problem I had with that, and still do, is that one, the court is determining what witnesses are most effective for the defense. And two, the court is precluding me on behalf of my client from sharing with the jurors my perception of the state's theory of prosecution. Additionally, and this was over the strenuous objection of the defense,
During closing?
this was now during deliberations.
Okay, all right.
The jurors came back with their first question, asking
I don't think he objected.
specifically whether Dr. Jason Quintal reached the conclusions about Doug Benefield himself, or whether or not that was something, the characterization was something in the materials that Dr. Quintal had read. At that point, I thought it was pretty easily addressed by simply having Dr. Quintal's testimony read back to the jurors. Because make no mistake, I asked Dr. Quintal, and Dr. Quintal stated that he concluded his diagnosis of Doug Benefield was that he was, quote, super controlling, a real alpha male, as in don't even look at her, she's mine. And to my surprise, the court would not allow a readback of Dr. Quintal's testimony. Now, at that point, we can only speculate as to what the divisions were during the deliberations. But what we do know is that the jurors wanted to know, was this an independent diagnosis that this expert in trauma had reached on his own or not? The court deprived us of that opportunity by not telling the jurors that they were entitled to a readback if they wanted it. That's all I asked, is that the court tell them, if you have questions, we can have Dr. Quintal's testimony read back to you.
Okay.
Court.
We've watched so many trials since then. I'm conflating them. Jamie, I agree. He did not object to that. We discussed it at the time. And also, I do remember the judge arguing about telling the jury they could have readbacks, and said something like, it's obvious they know they can ask for readbacks. And we discussed this at length, just like we've discussed in several trials, how some judges would not allow the definition of reasonable doubt to be read as a jury instruction. I think that was Mississippi during Carly Gregg, where the judge said, oh, it's obvious. Reasonable doubt is obvious. We have learned from many trials that we watch, reasonable doubt is not so obvious. Judges are not, jurors are not lawyers, and they should be given a definition of reasonable doubt, in my opinion. And also, they were not specifically told that they could have readbacks, and the judge didn't allow it. That's what he's arguing now.
Refuse. We can, that
So-
the court tell them back if they want, telling.
Okay.
The court deprived us of that opportunity by not telling the jurors that they were entitled to a readback if they wanted it. That's all I asked, is that the court tell them, if you have questions, we can have Dr. Quintel's testimony read back to you. Court refused to do so. When the jurors came in and announced at 10:30 p.m. that they were hung, we begged Your Honor to send them home for the evening. There was no reason to keep them. There was nothing pending that required a verdict that night. The court refused. The jurors had been there more than 12 hours. Respectfully, again, the defense felt that it was the court's intent to drive a result that evening, and it was accomplished at Ms. Benefield's expense. So, to sum up, Your Honor, and to close, I can only tell the court that it was a very heated trial. I think the court, for whatever reasons, made an initial judgment and never changed its position. And as a result, our efforts were not what they could have been, and in particular, that we believe would have influenced the outcome, especially because there was not a conviction for the charged offense. The jurors obviously thought something happened in that house on that day. Something occurred in the past that affected Ms. Benefield's judgment. What they did conclude, which we're forced to respect at this point, is that the judgment that Ashley Benefield exercised on that day was faulty, and she did not have to shoot him. But make no mistake, they acquitted her of murder. So what we're left with is a woman who all her life has not the slightest blemish of being anything other than a good citizen, and who, in the court's own words, had the system fail her. She constantly made report after report to the authorities, who never took any action. You can't help but wonder what would have been the outcome of these events had Doug Benefield been charged with a violation of the South Carolina restraining order. Would they have ended up in this position? I also don't think the court can discount the acts of domestic violence, the independent acts, the acts that are established by Doug Benefield's own admissions.
If you're not looking at your screen because you're, cleaning, rage crocheting, speed walking, running the boardwalk, running the Strand in the South Bay, where I would like to be right now. But not if you're driving. Come take a look at the screen. Tell me if the judge doesn't look a little perturbed. And it's kind of hard because it's only his profile. He looks a little perturbed for being called out on the objection that I don't think Mr. Taylor made at closing. And he looks a little, I don't know, disinterested, like he's already made up his mind. But hold on.
Acts of domestic violence, the independent act.
Right there. I think he's mad.
The acts that are established by Doug Benefield's own admissions, and in particular, the justification that he gives for those acts. So if you conclude that Ms. Benefield was subject to abuse by Doug Benefield, then that has to affect the sentencing that the court imposes. If you conclude that she was not affected by the prior acts, the trustworthiness of which is hard to dispute given his own admissions, then I think the court turns a blind eye to independent evidence establishing that he was abusive. We know the one thing that Dr. Broder did get right was he spoke and concluded about what a wonderful mother Ashley Benefield was. I think it would be beyond dispute to say that this was an unusual act, an aberration from a woman who has no past whatsoever. There's nothing that can replace the loss of Doug Benefield's life. There's nothing that anyone's going to say to the Benefield family that's going to make them feel any better than they feel now. What I can only remind the court is that the independent evidence from Doug Benefield's side, the family thinks only the best. From Ashley Benefield's side, all the supporters think only the worst. We're compelled to look to the independent perception of Doug Benefield. And even were the court to discount Dr. Russell's testimony, that still leaves Bruce Ferris and Dr. Quintal. And that testimony establishes that Doug Benefield had a deep-seated issue with abuse. It doesn't mean that the family didn't love him, but he would not be the first person that loved ones don't recognize has an issue. And if Miss Benefield was subjected to abuse, then that's something that Your Honor must take into account in applying an equitable sentence. I hope the court is strong enough to do just that. Thank you.
All right, before I go to the state, I do have a couple of questions. Sir, in your memo, this is regarding downward departure bases. I'm starting with statutory.
Yes.
Under 921.0026 subsection 2.
Yes.
In your written documents and today, you focused on F. Victim was initiator, willing participant, aggressor, or provoker of the incident. And G, defendant acted under extreme duress or under the domination of another person. However, you also elicited testimony from Dr. Russell today regarding her diagnosis of Ms. Benefield with PTSD, explaining the genesis of that and how it could affect her. Are you seeking a downward departure under D as well?
It was not my intention to seek any other basis other than what was included in my written sentencing memoranda, but as the court knows, that was filed in advance because I had another trial out of town that I had to attend to. If the court wants to accept that as a potential basis, as well as aberrant act, that's fine. We would be quite content. Either way, our objective is that a downward departure would be appropriate. As the court knows, it comes in the form of two questions. One, is it legally available? And two, is the sound discretion of Your Honor, should you? That's up to the court. I believe we've presented the court with sufficient evidence for all four bases, but my written memoranda only includes two.
All right. Well, now, which one's the fourth?
The fourth would be aberrant incident, aberrant behavior.
Oh, isolated incident under J? All right. So and the reason I ask is it's not uncommon during a sentencing hearing for me to hear testimony or evidence presented by the defense that would is intended for mitigation, but actually goes to one of the downward departures. That's why I want to clarify.
Yes, thank you.
All right, that's for the statutory bases, D, F, G, and J. There's also non-statutory bases. In reading your downward departure, your sentencing memo, and today, you've spent a number of pages in the memo, and then a significant time today of your argument on individual and cumulative errors at the trial court level.
Yes, sir.
Are you intending that to be considered as a non-statutory basis for a downward departure?
I can't speak for Your Honor. I can only serve up what I believe contributed to us having a less than effective defense to these charges.
How does that affect the sentencing for today?
To the extent that the court felt that those incidents, and I say incidents rather than errors because that remains to be determined, and I respect the fact that we have a good faith dispute as to those incidents. But if the court decides that those incidents run, those rulings run to the court taking into account, well, maybe I did hold the reins a little too tight, and maybe as a result, the defense wasn't as effective as it could be, because after all, the court sits as the seventh juror. If you feel, knowing what some of the evidence was that did not make it to the panel for their consideration, yes, you would be entitled to embrace that as a basis for departure. And if the court chose to do that, we would be grateful.
All right. That's what I wanted to know. It'll be, say, footnote or parenthetically, certainly if someone can't suffer the slings and arrows and take the criticism, they certainly shouldn't be sitting in this seat. You have absolutely every right to disagree and appeal, and that's what I expect. It's part of the process. My question is this then. In my years, in researching and dealing with downward departures, I am not familiar with, I haven't seen any support, obviously because non-statutory bases are coming up through the common law, through court decisions where those matters have been recognized. The statute leaves it wide open, right? Any other bases that the court believes. So that's where we have the this non-statutory downward departure bases. I am not familiar with individual or cumulative errors by the trial court being used or cited as a basis for a downward departure. So that's where I was ultimately going with all that. If it's intended to be a non-statutory downward departure, is there any support in the case law for that?
I'm not aware of that specifically in and of itself, but I will parse, if the court will, the substance of what I've had to say. And for example, as it relates to the first basis of departure, the victim's conduct, the court can well take into account the admissions that were made by Douglas Benefield in the deposition. The court can well take into account Ms. Benefield's letter that she left for Douglas Benefield. We may argue and dispute whether or not those two things should have been considered by the panel, but that does not preclude Your Honor from embracing them and reaching a determination for a downward departure.
Understood. All right. The next one was specific to G. I understand arguments and bases for D. I understand and appreciate your arguments for F. G, however, G is acted under extreme duress or under the domination of another person. And I'm just going to phrase it as walking around knowledge of that statutory basis is it's generally a confederate or a co-conspirator or a principal to the offense, as opposed to that basis being used for the victim. The victim is the one that was causing the duress. That's where I think F comes in. The victim's the initiator, the aggressor. So do you have any case law or any law for me that G can also apply, the duress portion can be applied from the victim in the matter as opposed to a confederate, co-conspirator, or principal.
Yes, I don't have a case at hand for the court, but the distinction I will make for the court is let's not be too narrow and interpret that only as it relates to the incident itself. The point I tried to make through the testimony of Dr. Russell was that Ms. Benefield's state of mind on that day, given the prior history of domestic abuse, when in the company of Douglas Benefield, already created in her, because of this past trauma, extreme duress. And I understand the court's distinction, but I do not believe that there is any case law that says that the duress is limited to the moment of the act. I believe the duress can be present from prior occasions, and that was the point I wanted to establish for Your Honor.
All right. Final question. You had mentioned about Dr., and this was both in your memo and in your statements today, Dr. Broder's testimony where I don't know what the best word is. I'll say walked back his testimony from the stand your ground hearing.
Yes, sir.
I'll just characterize it that way.
Fine.
And you talk about, so we had the stand your ground hearing. It was my understanding from the reading, because he wasn't impeached with any deposition testimony at the stand your ground hearing. The deposition you're talking about happened after the stand your ground hearing.
Correct.
Okay. All right. That was all my questions. Did you have any further statements you want to make in response to the questions I've asked?
No, other than even though the deposition of Dr. Broder occurred after the testimony, it doesn't lessen what we perceive was the court's linchpin for the stand your ground order, which was tied to, at best, a mistaken statement and at worst, a false statement to mislead the court.
I understand. Thank you. All right, State.
Judge, I'm not going to address
Buckle up,
the
buttercups.
alleged errors and things that happened during the trial. I believe that's not appropriate for the sentencing. While I do disagree heavily with most of what he said about those issues, I'm not going to address them independently. I do want to address some of the things that the defense said about what knowledge we have of this situation. So the defense kept saying the word independent evidence over and over and over, and that the court should look to the independent evidence of Douglas Benefield's behavior to support some of these downward departure reasons. However, I have arguments about some of those things that the defense said. For instance, the defense wants you to look at Doug Benefield's deposition testimony that was not allowed to come in to the trial. And we all know that there were reasons that was not allowed to come in the trial. It was following the rules of evidence. However, I can represent to the court that at least one of the things that Mr. Taylor said is completely inaccurate, that Doug Benefield, while he admitted to firing the gun, he never said he did it to intimidate her. So I would just ask that we be cautious about what we are presenting as fact when it is not necessarily fact. The defense also said that Doug Benefield violated the South Carolina injunction. That is also one thing that was never established definitively one way or another, whether he violated it. The defense said that Doug Benefield was caught by a neighbor spying into the house. There are differences of opinions as to that. And I think we went through that in trial, that it was just supposition and someone being identified by a voice after the defendant played a voice recording for her. So that's in dispute, whether he was actually there or not. So to take all of these things as factual and allow them to be used in such a way to say that he was a willing participant in this set of behaviors, I would argue is inaccurate. The defense also said that Dr. Quintal said that Doug Benefield was super controlling and an alpha male. But if the court recalls from trial in cross-examination, I asked him, is this opinion based on, at least in part, based on what Ashley Benefield is telling you? And he said yes. So it wasn't that it was his own independent evaluation of Doug Benefield. He was taking what this defendant was saying to him and incorporating that into his opinion. The defense also said that Dr. Ferris said that Doug was a classic abuser. The court, in the state's opinion, correctly ruled that that was inappropriate opinion testimony and was not allowed in front of the jury. And again, there are all kinds of reasons why that's not appropriate evidence to be considered by the jury. And I would say it's inappropriate for the court to consider that as fact in a sentencing. So what we do end up having is bits and pieces of a rocky marriage that in the state's argument do not rise to prior acts of domestic violence. Doug Benefield had problems. He lost his temper sometimes. So did the defendant. They had arguments. It was a marriage, and that happens in marriage. The victim, was never an abusive husband the way the defense keeps trying to represent. That is a fictitious idea that Ashley Benefield has put forth and guided through this entire process. And Dr. Russell even said today and acknowledged that she knew that Ashley Benefield had been diagnosed with histrionic personality disorder, and that one of the symptoms of histrionic personality disorder is that you tend to exaggerate
I had to step away.
and blow things out of proportion.
I had to step away. Step away for a second, but I was listening on my phone, and my phone is a little bit behind the actual court feed. So I want to take a step back and rewind about the rocky marriage and no evidence of, hold on, because all right, let's go back to here. I have some things to say.
So that's in dispute, whether he was actually there or not. So to take
Hold on. Okay.
differences of opinions as to that, and I think we went through that in trial, that it was just supposition and someone being identified by a voice after the defendant played a voice recording for her. So that's in dispute, whether he was actually there or not. So to take all of these things as factual and allow them to be used in such a way to say that he was a willing participant in this set of behaviors, I would argue is inaccurate. The defense also said that Dr. Quintal said that Doug Benefield was super controlling and an alpha male. But if the court recalls from trial in cross-examination, I asked him, is this opinion based on, at least in part, based on what Ashley Benefield is telling you? And he said yes. So it wasn't that it was his own independent evaluation of Doug Benefield. He was taking what this defendant was saying to him and incorporating that into his opinion. The defense also said that Dr. Ferris said that Doug was a classic abuser. The court, in the state's opinion, correctly ruled that that was inappropriate opinion testimony and was not allowed in front of the jury. And again, there are all kinds of reasons why that's not appropriate evidence to be considered by the jury. And I would say it's inappropriate for the court to consider that as fact in a sentencing. So what we do end up having is bits and pieces of a rocky marriage. That in the state's argument do not rise to prior acts of domestic violence.
Stop.
Doug Benefield.
Full stop. Firing a gun in the ceiling shouldn't be considered domestic violence. I don't know. It's happening inside the home. Punching a dog in the face so hard that you render the dog unconscious should not be domestic violence because He didn't punch her in the face. He just punched the dog in the face, right? Throwing the cat into the wall, down the stairs. None of that is domestic violence under her definition of domestic violence because although it happened inside the home, he didn't throw her down the stairs or throw her head into a wall. You can let me know your thoughts, but you know, this is why a lot of women don't come forward. This is why a lot of women don't prosecute. This is why a lot of women drop charges. It's why a lot of women bail their abusers out, because how bad is it going to get if you don't?
Benefield had problems. He lost his temper sometimes. So did the
He lost his temper sometimes. So did the defendant, she says. Everything that she is saying right now, if I was a judge, and thank God I'm not, would make me go for downward departure, because in my opinion, she's even proving the case more. How many times is a man allowed to punch a woman before she's allowed to be afraid, right? Was she afraid for her life in that moment? Had she seen him do these other things, and her experience of seeing him do these other things, did that factor into her fear for that life that day, being cornered into a little tiny bedroom by a man who takes a fighting stance, who was some sort of, I don't know, jujitsu black belt? I don't even remember now his fighting experience that he had, but who took a fighting stance that when this prosecutor made Ashley Benefield reenact in open court, openly mocked her for going like this. Okay. How many punches is a guy allowed to have? And because he didn't punch her once, are we to feel like she was not in any way being abused and was not in fear for her life? This is where I have a problem with this argument. And yeah, it happens. Lost his temper, it happens. What if something did happen? What if he took his fighting stance, she didn't have a weapon, and he tackled her and started choking her to death? We see a lot of those cases too. He was known to carry. The fact that he didn't have a weapon on him that day, or that he put his weapon somewhere while he was helping her move boxes or moving boxes or trying to control her move and trying to control where the boxes were placed in the truck, and then following her and moving with her to Maryland or wherever they were going, tried to rent the house directly behind her, was still stalking her from several states away. Nobody would in the state of Florida would recognize the order of protection that she had against him in one of the Carolinas. How many times was he supposed to be allowed to lay hands on her and punch her in order for her to be afraid and to make it okay for her to defend herself against this guy? And I would submit to you that she was lucky enough to get herself out of the situation of living with him and to get her daughter away from him before it could get to that point. She was one of the lucky ones. But this prosecutor wants to make everyone believe that because we don't have any evidence or didn't see any evidence of him physically punching her in the face ever, that she didn't have the right to fear for her life. And that's a huge misconception, in my opinion. And a lot of people think Ashley's faking. Look at her. She can't even make eye contact with anyone. In my opinion, her visceral reactions when she was testifying, the uncontrollable shaking, the inability to make eye contact. In my opinion, she presents as someone who is not faking and who is still in fear of this man who is dead. It's my opinion.
Doug Benefield had problems. He lost his temper sometimes. So did the defendant. They had arguments. It was a marriage, and that happens in marriage.
It happens in marriage. Have any of you been married and had a guy pick up his gun and shoot it at the wall behind you to scare you, or into the ceiling in your direction to scare you? Is that just losing his temper and we should just accept that as proper behavior? Look at her. She can make eye contact with anyone. I also think Sarah Boone was also probably abused. But look at the difference in demeanor. I don't think that anyone can sit here and judge, oh, well, she behaves this way, so therefore she's faking. Oh, well, Sarah Boone behaved this way, so therefore she was faking. Every person in that situation is going to have a different response to that. And there is no right way for a person to respond, in my opinion. Ashley was lucky enough to be able to get away, and she wasn't living with him at the time. And that's why she wasn't even allowed to bring up battered spouse.
Never an abusive husband the way the defense keeps trying to represent. That is a fictitious idea that Ashley Benefield has put forth and guided through this entire process. And Dr. Russell even said today and acknowledged that she knew that Ashley Benefield had been diagnosed with histrionic personality disorder, and that one of the symptoms of histrionic personality disorder is that you tend to exaggerate and blow things out of proportion. And that is the state's entire theory, is that this particular defendant just blows things out of proportion and makes things into something that never existed.
She blows things out of proportion, but the punching the dog into unconsciousness, the throwing the cat against the wall and throwing the cat against the stairs, and then shooting the gun into the ceiling and then throwing the wall. I think at one time he threw the gun at the wall behind her. All of those things were admitted. Those were the things that he admitted to doing. So those were not histrionic things. He put a tracker on her car. He was stalking her. Didn't the real estate person come in and testify that he wanted to rent the house directly behind her when there was an active restraining order in place? That's not histrionic, ma'am. That's what really happened here.
Entire theory is that this particular defendant just blows things out of proportion and makes things into something that never existed. So the court should consider that in trying to determine whether this victim somehow played into this
victim.
whole
I mean, you
incident
can even sense the disdain in her voice. This victim. She might as well have done air quotes. Listen.
The court should consider that in trying to determine whether this victim somehow played into this whole incident that happened the night of the shooting. One of the other things that I will mention from what the defense was alleging was improper rulings by the court, I do want to say in isolation just this one thing. The DNA report, the defense was saying that it would have shown that Doug Benefield's DNA was on Ashley Benefield's arm. Mm-hmm. And I believe that's a false statement. It would have shown that there was some DNA on her that could have been Doug Benefield's DNA, but it also could have been a family member. And the child that was a toddler at the time was clearly a family member. So to imply that the DNA report would have...
The toddler was a female, wasn't it male DNA? I don't recall now at this point. Right, histrionic personality disorder has jack to do with this.
Clearly shown that Doug Benefield was holding her, and at the time that this incident was going on, I believe is not an accurate statement. So as far as the defendant being a willing participant, the victim being a willing participant, we do only have Ashley Benefield's version of events for that night. That's all we have. And I know the defense
we have the neighbor's version.
Motion or in the memorandum has mentioned that the court should take what she says as truth, that it's uncontroverted and unimpeached. But I have a case here, Judge, it's Early versus State, 223 Southern 3rd, 1023, which is a First District Court of Appeal case from 2017. And while this talks about a jury, it does give guidance as to the type of situation that we have here. Even when there is no other witness to the events besides the defendant, a jury is not required to accept the defendant's testimony in support of his self-defense theory as true. Instead, it must consider the probability or improbability of the defendant's credibility in light of the circumstances established by other evidence. So I believe that the court can wholeheartedly believe what Ashley Benefield said on the stand, or the court is allowed to disbelieve everything she said on the stand. And if that is the basis for this downward departure request, that he was a willing participant or an instigator, the entire evidence that we have of that comes from Ashley Benefield herself. And the state argues that
Here's
her
the
credibility.
thing, ma'am, counselor, sister, my sister. Nobody testified. I don't think Doug Benefield had anyone who really knew him, right? Cousin Tommy rarely saw him, didn't even know he married Ashley. There were no members of Doug's family that really even knew him. In fact, when Eva got up to just give her victim impact statement, and my heart breaks for her, she's lost both of her parents. I'm going to show her some grace. I think we all should. Nobody should have to go through what Eva went through. But this man got married to Ashley without even telling his daughter. He kept it a secret from her. And I think we heard her in her victim impact statement saying that she hardly ever saw him. That even though, I mean, I don't think there was anybody who really knew Doug Benefield. I think the person who knew Doug Benefield the best, besides Ashley, was Stephanie Murphy, his lawyer. She's the only one who really got up to talk about him and his behavior. And she seemed to idolize him in some weird way, that weird attorney-client relationship. Was there anyone, refresh my recollection, I know we've watched a lot of trials since then. Did anyone get up on the stand to talk about knowing Doug Benefield? Yeah, his late wife, right? The messages were found between Doug's late wife and him, talking about how he beat her on the honeymoon. Who said he was also an abuser, right? He kicked her so hard on their honeymoon. So exactly, there was no one. So when this prosecutor says the only version we have is Ashley's, yeah, because nobody else knew Doug Benefield. I'm just going to take that back a second.
This is for this downward departure request, that he was a willing participant or an instigator. The entire evidence that we have of that comes from Ashley Benefield herself. And the state
Nobody got up
argues
to
that her
Stacey. Nobody
credibility.
got up to testify. Nobody got up to testify, is what I'm saying. Just because they didn't show up in the court, they may have been in the courtroom. I don't know. Nobody got up to testify, is what I'm saying.
Is below, much below where it should be, and that it is obvious this was a pattern of behavior, that she had a goal to raise this child by herself and to get Doug Benefield out of their lives, and this was the culmination of that pattern. And so her credibility is lower than it should be. The other downward departure reasons that the defense mentioned, the one was the PTSD.
I have the denial of the motion for the new trial. It just came onto the docket late yesterday, so I'm going to read it after this, Olivia. But no, he didn't care. He didn't care about that dishonest biased juror. We're going to read it after this.
But if the court looks at that downward departure reason, it says that that the defendant has a mental disability or problem that requires specialized treatment. And the defense has put on nothing to say that she needs specialized treatment for this, even if the court accepts that she does have PTSD. So the defense has not satisfied their burden for that. As far as isolated, the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. I would argue that does not apply. Obviously, this was not a one-time thing. This was a pattern of conduct over a very long period of time. Additionally, it's not unsophisticated. It's a culmination of a pattern. And if the court looks at the facts that came out in trial, that there were multiple firearms placed around the house, the daughter and mother were out of the house conveniently at the time when all of this happened.
Conveniently.
And this defendant is the only one
They went to the
still
park
alive
like
that
they normally
has
did
the
at that
correct-
time.
What she's trying to say is the correct version of events. So I would argue that that downward departure reason.
Why would she send her mother and her daughter to the park, like as if this was some sort of planned killing? And then what? And then she's just gonna hope. I mean, they want us to believe, or you to believe, or the judge, or the jury, or everyone in the world to believe that Ashley Benefield plotted this killing. She sent her mother and her daughter to the park so that she could kill him, and then what? And then hope that she gets off on self-defense. If she was gonna do this, don't you think maybe she would have instigated him into sort of like inflicting some sort of actual like physical abuse on her before she shot him, so she would have a better argument for self-defense? It makes no sense to me. She planned to kill him and then what? Roll the dice like she did here? It doesn't make sense. That argument doesn't make sense to me.
Does not apply, or the defense has not met their burden.
Exactly. She's convicted of manslaughter, by the way. I just saw Kurt say
And
she's convicted of second-degree murder. No.
Judge, I think it's very difficult when this entire trial has been about pretty much demonizing Doug Benefield and making this defendant the victim, when in fact it was the opposite. Doug Benefield did nothing but try to love this woman and try to love this child and try to do the best by them. And at every turn, she
Is that loving?
abused him, in my opinion. She tried to withhold this child. She tried to get him in trouble at every turn. She tried to do everything to undermine any relationship that they would have. And he continued to go back, which was probably his one fault, was that he continued to go back and he continued to think that he could make this work. And this defendant
He wanted to
took
control
advantage
her.
of that. And then when she can't get relief from anywhere else, shoots and kills him. And she got exactly what she wanted for a time. And for that, Judge, we would ask that you sentence her to the maximum 30 years.
She got exactly what she wanted. Okay. All right. I can't even with this. I can't.
Thank you. Rebuttal.
She wanted to leave her child with a mother in jail and no father. That's what she wanted to do.
Okay, so at this point, I've heard all the evidence. I've heard the arguments of counsel. Ms. Benefield, this is addressed to you. Please feel free to consult with your attorneys before you answer, or if you want to answer. But at this point, I always just check with the defendant and say, okay, I've heard. Of course, there was a stack of letters that I got from your attorney as part of the downward departure. Heard Dr. Russell's testimony today, of course, presided over the entire trial. Heard the statements from the state as well. I always ask, though, is there anybody that I haven't heard from, any testimony I didn't hear, any evidence that I didn't hear, anything at all that I need to know to make a fair decision in this matter?
Your Honor, Ms. Benefield feels that I've spoken for her.
Excellent. All right. I also give a final statement, and I'm sure that you and your attorneys have talked about this at length. You are absolutely not required to make any statement. However, I also, whenever I have a trial case, we're doing sentencing, if it's an open plea. I do always give the defendant the last opportunity if there's any statements that you want to make. You're absolutely not required to. I'm sure you've already talked to your attorneys about it. But if there's any statement.
Based on the way that she was treated during her cross-examination, I don't think she has the guts or the courage or even the ability to stand up and say anything right now. Do you? Look at her. She's totally disassociating. She has seen the way that she's been treated in that courtroom. I don't think she's going to say anything. Do you? Would you? Can other women be misogynist? Yeah. They're all on Twitter, Gregor Smith.
If you want to make, please feel free to do so. If not, we'll just move on with sentencing.
I know the court won't interpret her choosing not to as a lack of invitation.
Fair enough. And as I said, you're not required to at all. All right, is there any legal reason why sentence cannot be imposed? All right, so the first thing we need to do is talk about the bases that have been argued for downward departure. And I think today it's an absolute tragedy that we're even here today. And I often, in these situations, sit back and wonder, how did we get here? How did life bring us to this point, not only here in court, but between the Benefields? I think both sides have acknowledged, because both the defense, Mr. Taylor, and the state talked about lenses and perspectives. And I think this is a good example of exactly that, where whatever lens you view this case from can really affect how you view the players, the results, the participants, and the outcome. So we've got the score sheet to start from. The issue is whether a downward departure has been sufficiently, the burden of proving that has been sufficiently met, and then whether the court would grant a downward departure. So the bases are, and I'm going to just take them in alphabetical order from the statute, 921.0026 subsection 2. The first one is D. The defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, or for a physical disability, and the defendant is amenable to treatment. In that particular one, there was the testimony by Dr. Russell that she has diagnosed the defendant with PTSD. It's a complex trauma. She explained the genesis of it and how she reached that conclusion. But importantly, what needs to flow from that is a description of what that specialized treatment is, what sort of treatment is important or would be necessary to treat that PTSD, inpatient, outpatient, what kind of mental health therapies, and so forth. So based upon the competent and substantial evidence that has been presented, I do not find that D has been proven by preponderance of the evidence, all the elements of D. F, the victim was an initiator, willing participant, aggressor, or provoker of the incident. The reason I asked that question, and I was looking around, is I had a case, and I thought I put it in my packet for today, but I'm not seeing it. There was actually a decision in the Florida Law Weekly within the past couple of months. It hasn't been too long ago, where that very issue was discussed. And the DCA in that case actually came down and said, when it talks about the incident, the evidence must support that the victim was an initiator, willing participant, aggressor, or provoker of the incident. And specifically said the court should not consider all of the pre-existing or attendant circumstances and just look at that incident. I think both sides took a great amount of time throughout this case to talk about incidents and events and happenings that occurred before September 27th of 2020. Do I have the date right? September 27th of 2020. But I think the case law talks about that particular day or that particular event. And it doesn't need to be, for this downward departure basis, the law is very clear. The defense doesn't have to prove it by clear and convincing evidence beyond a reasonable doubt. They don't have to prove or provide evidence that is beyond a reasonable doubt. The question is there competent and substantial evidence that in the incident itself, the victim was an initiator, willing participant, aggressor, or provoker of the incident? And quite frankly, the evidence, the preponderance of the evidence has established that Ms. Benefield's testimony
It's great for her.
is sufficient in and of itself. And I understand the state is arguing that to discount her credibility.
Yes,
But is there evidence
believes her
in the record
that he was the
that
aggressor.
proves by a preponderance that Doug Benefield was an initiator, willing participant, aggressor, or provoker of the incident? And there is. That was the entire basis of the self-defense argument.
God bless you, Judge. No
So I do
spoilers over
find
your
that,
head.
The requirements of F have been met. G, the defendant acted under extreme duress or under the domination of another person. This is why I was asking about the case law, because I have not seen this particular statutory basis applied in this particular factual scenario where it's argued that the defendant acted under the extreme duress of the victim as a self-defense matter. But just because I haven't seen the case law doesn't mean that it doesn't exist and it can't be argued for that purpose.
He's not afraid to
So
make
for
case
the
law.
purposes of today, using a similar analysis as I did under F, but also considering the
Life
past
is not on the
relationships,
table. Life is not on the
relationship
table.
between
It's
the parties.
manslaughter.
I think there has been competent, substantial evidence to establish by a preponderance that the defendant acted under extreme duress. The domination of another person, I just don't think fits. So to the extent that that particular downward departure basis requires that the duress come from a conspirator, a co-conspirator, a confederate, or a principal, I could be wrong, but I think it applies, and I'm applying it here. Or I think it's been proven. And then J was the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. The case that I talked about a few minutes ago regarding victim was an initiator, willing participant, aggressor, or provoker of the incident, J has similar language. The offense was committed in a sophisticated manner. So I understand the state's argument saying, hey, this was a whole series of events and was very sophisticated in its planning and execution. At the end of the day, the statute itself says the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. So if I look at just the incident itself, there's nothing sophisticated necessarily about self-defense and using self-defense. Isolated incident, the defense has pointed out, and the score sheet shows there are no prior acts of violence. There's no prior convictions.
Hey, John Roberts, I don't
The
know if
case
you're
law
ahead in the
requires,
stream, but
though,
stop
that
it with the
all three
spoilers.
Elements of this be established. The final one is the defendant has shown remorse. Obviously, she's exercised a very, very fundamental constitutional right by not making a statement today. But I can also, I believe, consider the testimony that was provided during the trial.
That's right.
And
how she was treated.
Remorse is not necessarily and doesn't have to be, I'm sorry I did this. Because someone is perfectly entitled to maintain their innocence, even in light of a verdict of guilty by a jury. So I find that during the trial itself, that Ms. Benefield did demonstrate remorse for this entire incident happening, and the culmination and the resulting death of Mr. Benefield. So I do find that J has been established. The non-statutory bases, there were none explicitly argued, but I'm going to make a ruling on the individual and culmination of errors for appellate purposes. Again, I'm not aware of any case law that establishes that. To the extent that there's an argument to be made that, and when I say individual errors, I'm talking about fundamental error, right? Because that could just be one thing and fundamentally vitiates the fairness of the entire trial. So individual or cumulative errors being the bases of a downward departure, I'm going to go ahead and make the finding that those are not, errors by the trial court are not bases for a downward departure, non-statutory
He's right on the law
bases.
about that.
I may be wrong. We'll find out.
I don't think he's right.
The second part of the analysis is whether the court is going to exercise its discretion to depart.
Wow, he's going downward.
And that's where
Wait, is he?
you really take into consideration those factors in determining, in light of all of the facts and evidence that have been presented, if this is a case that the court believes a downward departure should be granted. And as I said, I understand completely that two sides of this room are viewing this same case through very different lenses.
I hope he tells everyone not to make an outburst.
As I consider all of the evidence that I talked about earlier that I reviewed in preparing for today, the jury's verdict, which they did not find Ms. Benefield guilty of the charged offense. It was a lesser included offense that did not include depraved mind. It included doing an act which resulted in the death of another person. I consider the score sheet and what Florida statute or chapter 921 discusses regarding the aim of sentencing, that being the primary purpose of sentencing is to punish, the secondary purpose is to rehabilitate. The PSI, which has been reviewed and considered, and I understand throughout the arguments that the defense has raised their disagreements. For what it's worth, the PSI in the factual part really just recreates or retypes the complaint affidavit. I don't really put a lot of weight on that. I don't need that because I presided over the entire trial. So I don't put a lot of weight on the factual recitation that was in the PSI. And as we all know, the PSI is not controlling on the court. The probation officer who does the report makes a recommendation, but unlike in juvenile court, where the Department of Juvenile Justice's recommendation is somewhat binding on the court, the DOC recommendation is not, but I did review that. And of course, as I said, I reviewed the defendant's sentencing memorandum, all of the various attachments, and listened to the statements that were made today from Dr. Russell, as well as David, Wes, Tommy, and Eva Benefield. And all I can say is thank you to everyone who took the time to write a letter and share your experiences. A number of them talked about growing up with Ms. Benefield, their interactions with her as they've grown up and growing into adulthood. Thank you for the statements regarding your relationships with Douglas Benefield and how his loss has impacted each of you. So when I look at the bases for the downward departure and I consider all of the facts and evidence that have been presented to me, my ultimate conclusion, Ms. Benefield, is that this is not a downward departure case.
Oh, wow. I
So
thought he
with
was going
that
the other way.
said, the sentence of the court will be as follows.
Okay, I misread everything he said.
I'm going to sentence you to 20 years in Florida State Prison That's to be followed by 10 years of probation. Upon your release, and the Florida State Prison was, of course, with all credit for time served. You must initially report to the Bradenton Department of Corrections. We'll be able to provide you a map of where that is. Cost of supervision will be a condition of supervision. Based upon the testimony of Dr. Russell today regarding you suffering from and being diagnosed with PTSD, the court is going to order as a condition of your probation that you obtain a mental health evaluation at your expense within 60 days of beginning your probation. You're to complete any recommended treatment, including residential treatment and aftercare if it's recommended, on the first attempt at your expense. You're to provide proof to your probation officer regarding the evaluation, participation in, and completion of that treatment. If it's necessary for your probation officer, you'll sign any waivers or releases that are necessary for them to get the information that they need or speak with your evaluators and treaters. I am going to order the forfeiture of the firearm in this matter, that being the Springfield 45, and I'm ordering that you have given up all rights, title, and interest to the same. I haven't heard anything about restitution at this point. I am going to order restitution. I'll reserve jurisdiction to determine the amount of restitution, the payee or payees, the payment schedule, if any, and other terms and conditions of restitution. I'm also going to reserve jurisdiction on the restitution to determine whether or not to waive or reduce the monthly cost of supervision and or the fees and surcharges that are associated. I'm going to impose the following monetary obligations: the felony adjudication of guilt court costs, $100 cost of prosecution.
200.
Do you have an affidavit?
I don't have it with me.
look.
If you need one, we can get one.
It's required
Who
by
gives a duck
Florida
about
law.
the extra $100? Really?
If you want to
3,000
continue on,
pages.
we'll try and find it.
All right. If an affidavit is for cost of investigation is presented, I'll order $200 to the Manatee County Sheriff's Office.
He
For
believed
now,
everything
I'm
she
going to
said.
make
I'm
all the legal financial obligations a condition of probation. All right, State, now that you've seen where I'm at with the sentencing, was there anything that you want to do, any further arguments, anything else you want me to consider?
Judge, my only concern would be the mental health evaluation. I would prefer that it not be with Barbara Russell when she's on probation and has to do with mental evaluation.
You don't want what?
You have ordered that the defendant do a mental health evaluation when she gets out on
Correct.
probation.
After 20
And I would
years from
request it
now.
be someone other than any of the doctors that were involved in this case. So not Barbara Russell or Dr. Quintal or Dr. Broder.
girl, like you want to argue
Okay.
in apparently
I'm not gonna order
there's no like parole in Florida. She's got to serve the full 20 or she has to serve 85% of the 20. Either way, like today's the day that you want to pick the argument that Barbara Russell should not evaluate her in 20 years or 85% of 20 years.
I'll let you pick your mental health professional that you want to see and
Wait for
consult with.
her victory speech.
Sir, now
after
that I've told you where I'm at, was there anything that I need to explain or clarify?
No, sir. If you would, how long is the period of probation?
It was 10 years. Okay, Ms. Benefield, you have 30 days to appeal the judgment and sentence of, oh, yes, sir.
Make one statement for the record. I object for the record, argue it's an abuse of discretion based on the undisputed facts, not to grant a downward departure.
Oh, yes, sir. Absolutely. I think that's generally preserved no matter what, but
I do too, but.
I appreciate your belt.
But the appellate courts like to find not preservation, so I'm overly careful.
I understood. Belt and suspenders, no problem at all. Yes, sir. So objection to the abuse of discretion for not granting the downward departure. Noted. All right, Ms. Benefield, you have 30 days to appeal the judgment and sentence of the court. If you can't afford to hire a lawyer, one will be appointed to represent you. Go ahead.
I just have one thing.
Is it regarding appeal?
Regarding,
Appeal?
no,
Oh, well, go ahead then.
I was going to ask the court if the court would make arrangements to ensure that Ms. Benefield remains in Manatee County for at least 14 days, if not 30, so that we can tie up all the loose loose ends in preparation for.
Okay. I don't know how much pull I have over that. DOC comes gets people when they come get them.
Can I
There's-
suggest that Your Honor set this for a report in perhaps 30 days?
All right, why don't you send me an order directing the sheriff to hold her pending any final hearings or matters? And I'll,
Judge, the most specific thing, we're going to be filing this motion for bond pending appeal. So that's why.
oh, keep her there for that.
Yes, so to avoid the necessity of her going back and forth.
Absolutely. So do me a favor, contact Kelly, my JA, get that set. I didn't see it's been filed yet, but get it filed.
It has not, but I will file it tomorrow.
All right, get it filed. Talk with Kelly about getting a hearing date, and then I'll sign an order to hold her until after that date. Absolutely.
Thank you, Judge.
Thanks.
Of course. Okay, for the appellate purposes, what I was going to say is, ma'am, speak with your attorney. You can hire someone if you want, a private attorney for that. If ultimately you are going to seek the services of the public defender, I'll just need a financial affidavit and a motion to appoint. And then once Mr. Taylor completes all of his obligations as trial counsel, we'll get a local PD appointed and then the 10th Circuit PD. All right, ma'am. Thank you very much.
Ashley Benefield was just sentenced to 20 years in state prison plus 10 years of probation, and her daughter will be without her mother for the next 20 years. The sound is off, but let's just watch Ashley leave. From everything that he was saying, and the fact that he found her credible, the fact that he found her remorseful during her testimony, the fact that he felt that she was in fear for her life. I mean, didn't he say all of that stuff and then said, but I'm not going to downward depart? And gave her 20 years. I don't think that was the right decision. I just don't. She has 30 days to file a notice of appeal, and I am sure that she will. She will have an attorney file one on her behalf. If not Mr. Taylor, then it will be someone else, an appellate attorney, typically. She will do 17 years minimum. Thank you, Jamie. I think that this was the wrong decision on many, many levels. That is my personal opinion. MD says she's shown remorse the entire time. Remember, I think it was during the Benefield trial, if I'm not mistaken, Marsha Thompson, who was another woman in Florida who shot her husband many times as he slept on the couch in their house, was acquitted. She was acquitted. The difference in that case was that he had beaten her for many, many years, physically beaten her. So I guess maybe if you're in Florida, that's what you have to happen. I mean, let yourself be physically beaten. Don't try to get away. And then if something one day happens and you kill your abuser, well, then maybe you'll have a shot at getting off, but not in this case. Not in this case. I'm going to go to the chat and then I'm going to read you the decision from denying where he talks about the juror issue and the misconduct of the juror and what he thinks and why he decided not to grant a new trial. David, thank you so much for hanging around for 6 months. On top, thanks for your super sticker. Ducking under advisement. Thanks for the 5 praying. He has leniency with her sentence. Nope. Well, the max was 30, so gave her 20. Ashley doesn't deserve to be in jail, but home with her daughter. I happen to agree with you. Yellow gosh. Oh, David, you changed your name. Still can't believe she was even charged in Florida. Well, look what happened in Massachusetts with Brian Camp. I couldn't believe he was charged either when a home invader broke into his house and tried to kill him. But he was acquitted. So that was good last week. If you didn't watch the Brian Camp trial, please do. That's another Massachusetts travesty. Loudmouse, thank you for the 5. Please look up Richard Moore in South Carolina. He got the death penalty. The judge, prison director, psychologist, and jurors are asking the governor for clemency. Thank you for that suggestion. Amy, in Boston, as somebody with CPTSD, with moons people can't see. It's a shame when we're mocked and told nothing is wrong with us. Shame on you. Thanks, Amy. Miss Garbage Brain. So loves me. I'm going to step out of the stream for my own mental health. That was probably a very wise decision. Miss Garbage Brain, thank you for being our incredible advocate. Thank you for knowing enough to take a break from this when you felt that emotionally you couldn't handle it. I commend you for that. Thank you, Wanda from Canada. Thanks for putting that YouTuber in the place. I appreciate you and thank you. Thank you so much. Strong Women Unite. We try. You know, I got to digest this a little bit more before I can fully form my thoughts, but that may happen in the next half hour while we go over this next motion. These men and all their audacity is waking me up better than my coffee, says Brooke. Thank you for your 5. Mike B from the 413. Why didn't the prosecutor or victim advocates review and help edit these statements? I believe that they did. But this prosecutor in particular, Suzanne, I forget her last name, O'Donnell maybe, has been pushing the boundaries of what's ethical and proper demeanor and conduct for a prosecutor throughout the entire trial and beyond, to infinity and beyond. So there's that. And I think she did. And to comply with the rules, I think she's pushed the boundaries a lot and every objection was sustained. So that was good anyway. Nicole says, thank you. And I thank you back. Why are they swearing them in? Because they have to agree that what they're saying is true. Maybe it's a Florida thing. I don't know if we saw that. And I don't think we did see that yesterday in South Carolina when we watched the sentencing hearing for Jamie Lee Komorowski, the drunk driver, alleged drunk driver. She pled guilty. So, who killed the bride on her wedding day, who was in a golf cart. And the Jamie Lee, the defendant, was at 3 times the legal limit. Her blood alcohol content was 3 times the legal limit. She, in a rental car, slammed into that golf cart at 65 miles per hour in a 25-mile-an-hour zone. That was heart-wrenching. Bianca, thank you for your super sticker. Dawn says they feel for his daughter. Thank you so much, Dawn, for the 10. And then another 10 says my parents, not my dad. I'm not sure what that's referring to, but thank you again, Dawn, for your generosity. Thank you, Ducking Bianca, for thanking me. I appreciate you. And to the amazing, generous gifters today, not cupcakes, gifting 10 memberships. Thank you so very much. Susie Costello, who also gifted 10 memberships. Thank you so very much. And not cupcakes again with another 10 and then another 5. That's 25. Wow, not cupcakes. Thank you so much. That is really, really generous. And to all of you who are gifted memberships today, welcome. And thank you for the generosity of these amazing, amazing viewers today. I appreciate you more than you know. And then not cupcake comes in the moon with another 20 and says, my username has nothing to do with your cupcakes. I somehow got the nickname Cupcakes when I was 6 or 7 years old. That's so funny. That nickname no longer works for me, so I'm not Cupcakes. That's so funny. Thank you for telling us that. And look at Elizabeth coming in and gifting 5 memberships. Thank you so much. Elizabeth Mullins, Lupus Lady, thank you. Terror Tooth, thank you for the 50. This is true in all of life. You can forgive the lack of ability, but not ignorance. Look the other way is also not a way to live. I agree with you. It's called integrity. Corruption is real. Love you too. And the moderators, thank you. This was rough today. I didn't think I after I saw what was happening this morning, I set this stream to subscribers for a week or more. Because there were some people, it was originally, I think, at 20 minutes. There were some people who actually waited 20 minutes after hitting the subscribe bell to start in with their nasty bullying type comments. So thank you so much. And Lori Jean, thank you for tuning in from Canada, who said, I believe Ashley should spend some time in prison. She wasn't in fear at the time. I saw what wasn't allowed in. The abuse wasn't like it was claimed. Sorry. I think something would have been fair also. I don't think, there should have been nothing, but I also think that 20 years is too much. That's my opinion. It's my opinion. Why have a stand your ground if it's not going to be allowed? Thank you on top so much for your super sticker. And for Melanie, another Melanie. We have so many Melanies in the chat for becoming a member. Amber, I'm still stuck out of mind warfare for 3 years. Oh, girl. You got this. Giggles, thanks for devoting so much time and sharing your professional opinions. You're loved and valued. Thank you, Giggles, so much for your 10. Wendy coming in with a 20. Thank you. I still have the image in my mind of this prosecutor mocking Ashley, explaining the fighting stance Doug took when she fired the weapon. Yeah, me too. Picture Bruce Lee, the stance in one side and out the other. He'd kick her. Yeah. Thank you, Susie, for the 50, who's thanking me for truly getting what happened to Ashley. I don't know. I consider myself to have a good intuition and I'm not a body language expert. I'm not I'm not an interrogator from the CIA who can, tell people's body language or tics that they make when they're lying or telling the truth. I just think I'm someone with intuition. And I think my intuition is usually right. And I think that when you have a gut feeling, that is your intuition trying to tell you something. I believed her. I still believe her. Thanks, Wendy. You think his wife and daughters gave him a talking to after the trial? You're talking about the judge? I don't know, because I thought he was going in one direction and then he decided not to. So perhaps my intuition with regard to that judge was not so great. Chatsy is outraged and heartbroken. I think you're not alone here. Plant Lady is absolutely disgusted as a DV survivor. This literally makes me physically sick. There's a lot of people who feel the same way. Blessed Mom from Texas, thank you for the 20. Love to all DV survivors. We are here for you. Loves us all. Like the video and sub up, please. Hit that bell. Lots of new people here. Be kind, be classy. Thank you. Blessed Mom from Texas. DK, thank you for your 20. This sends such a sad message to the victims of DV and standing up for themselves. Thanks for covering this case. Speaking as a victim of DV myself, no justice was done here. Just more pain to victims of DV. Thanks, D. D's an OG. She's been with me for a long time. Thank you, Joseph Kane, for your super sticker. All right. We are going to take a look now at the decision that came out yesterday on the motion for the new trial, where the judge goes over his reasoning for denying that based on the juror hearing. So let's take a look at that, because I'd been waiting for that, and I sort of was waiting and waiting and waiting. And I said, how can they do a sentencing when the judge has not ruled on the motion for a new trial? And then it popped onto the docket. It popped on the docket yesterday afternoon. And after I'd been on the air for so long with 2 different streams, I just did not have the energy. I just didn't have the energy to do it, but we're here. I don't know how much energy I have left, but I think we need to go over it, because we have not. So let's take a look. Hot off the press from yesterday. And I did have a little soft spot for this judge. I kind of thought he was fair. I don't know what I feel anymore. I think I'm just numb to all of this. All I can say is thank God for Brian Camp and for his attorney, Tom Kokanowski, who came on the show with me the other day. And I think I need to get Tom back on the channel like soon, like maybe later today. Tom, I don't know if you're out there, maybe you're in court today, but bat phone to Tom, because that was a great show. If you didn't watch it, please watch it. He is a defense attorney who gave so many of you and us faith in defense attorneys and the justice system. And I think we needed it. Now we need it. We need it even more. I think we need it even more. Oh, for the love of the traveling Mary, here we go. Buckle up. This was dropped. It says it was e-filed on the 27th of November. It was not in the court docket until yesterday, which was December 2nd. So I don't know. Maybe it was Thanksgiving. No, I think that's probably what it was, right? Because the 27th would have been, where's my calendar? 27th was the day before Thanksgiving. So maybe the clerk got to leave early that day, and then maybe the clerk was not in on Friday. And so that's why it didn't hit the docket until actually yesterday. But here was the order denying the defendant's motion for a new trial. So the defense, as you know, made a motion for a new trial based on 3 different things: prosecutorial misconduct during closing arguments, juror misconduct during deliberations because the person named That Hoodie Guy went into the law and crime chat saying that his sister was on the jury and that she had a phone and she was feeding him the information. And then That Hoodie Guy was in the law and crime chat saying what was going on in the jury room. That was the juror misconduct during the deliberations argument. And then the third argument was juror 15's failure to disclose information during jury selection. This is 11 pages. I'll try to not interrupt too much with my thoughts because otherwise we'll be here for even more than the 3.5 hours we've been here already. But I think it's important for you to hear the decision on this motion since we went over the initial motion papers, the opposition papers, and the hearing on this motion. And it took so long to decide. Here's the order denying defendant's motion for new trial. This matter is before the court on defendant's motion for a new trial filed August 9th of 2024. On November 16th of 2020, the state charged defendant with second-degree murder with a firearm, a life felony under these Florida statutes for the fatal shooting of her husband, Douglas Benefield. At trial, defendant argued she shot Mr. Benefield in self-defense. On July 30th, 2024, a jury found the defendant guilty of the lesser included offense of manslaughter. Defendant now seeks a new trial based on claims of prosecutorial misconduct during closing arguments, juror misconduct during deliberations, and juror 15's failure to disclose information during jury selection. The court conducted an in-camera interview of the jurors in this case on October 4th of 2024 and heard arguments on the motion on October 21st of 2024. The court has evidence and argument from these hearings, the responses and memoranda filed by the state and defendant, the record, and applicable law. For the reasons discussed below, the court denies defendant's motion for a new trial. The court finds the challenged statements by the prosecutor were not improper or did not amount to fundamental error, either individually or cumulatively. The court finds the juror interviews failed to substantiate the allegations of juror misconduct during deliberations. Finally, the court finds that the alleged non-disclosure by juror 15 were attributable to a lack of diligence by defendant's counsel or disclosure of the information would not have resulted in the exercise of a peremptory strike by the defense. Point 1, prosecutorial misconduct claims. Defendant claims she's entitled to a new trial based on multiple alleged instances of prosecutorial misconduct during closing arguments. Generally, to warrant a new trial, a prosecutor's improper comments must either deprive the defendant of a fair and impartial trial, materially contribute to the conviction, be so harmful or fundamentally tainted as to require a new trial, or to be so inflammatory that they might have influenced the jury to reach a more severe verdict than it would have otherwise. However, the record reveals that the defense did not make a contemporaneous objection to any of the alleged instances of prosecutorial misconduct. Under these circumstances, defendant is only entitled to relief if the comment constitutes fundamental error. And remember, Jamie, if you're still here, many of you said we were screaming for him to object during the closings. And then, in fact, he just told the judge that he did object during the closings. And the judge's decision with, I don't know if Mr. Taylor read that, read this decision yet, but I guess he did, but must have forgotten. Fundamental error reaches down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. Several of the allegedly improper statements by the prosecutor, including arguing that defendant's behavior was manipulative, asserting that a defense expert was being paid for their appearance in court, and quoting the jury instructions on the issue of self-defense, were not improper and not grounds for an objection or a new trial. Further, none of the alleged instances of prosecutorial misconduct amount to fundamental error, either individually or in their cumulative effect. Accordingly, defendant's request for a new trial based on prosecutorial misconduct is denied. I also did not agree that that was the strongest argument. In my opinion, when we went over these papers, discussed it at length, my opinion of the strongest argument was the juror 15 claims, which we're going to go through and we'll spend more time on that. So point 2 is the juror misconduct claims. Defendant's claims of juror misconduct fall under 2 categories. First, defendant alleges an unidentified juror brought a cell phone into the jury room and used the phone during deliberations. Second, defendant alleges several instances where juror 15 failed to disclose material information during jury selection. During the in-camera interview, the court questioned each juror individually about the alleged use of a cell phone during deliberations and further questioned juror 15 about the information she allegedly concealed. After initially questioning each juror, the court allowed the parties to request additional questions for the court to ask. Defendant requested 2 additional inquiries related to juror 15, and the court made both requested inquiries. So remember that hearing was not televised because obviously the jurors could not be made public. And so we did not see that in-camera interview of all the jurors, but the court's going to tell us a little bit about what happened during that. A, use of cell phone during deliberation. Shortly before the jury returned its verdict, user That Hoodie Guy posted comments on the YouTube broadcast of the trial by the Law and Crime channel claiming one of the jurors was his sister who brought a flip phone into deliberations and texted him that the jury was split 5-1 on a guilty verdict and may compromise on manslaughter. Defendant claims entitlement to a new trial based on this alleged juror misconduct. The court questioned each juror individually about the alleged use of a cell phone during deliberations. After clarification of when deliberations began and the precise time period at issue, each juror testified that they did not have a cell phone with them during deliberations, did not observe any other jurors with a cell phone during deliberations, and did not observe any other jurors who were isolated for an extended time during deliberations. Neither defendant nor the state requested additional questioning of any jurors on this issue. This is interesting too. I'm just going to break from the document for a second because sometimes right now there's 3,200 of you. At one point, there was over 4,000 of you in here yesterday. I think during Aiden Carney's hearing, we had over 6,000 people in chat. And at some points during the Karen Reed trial, we had something like 18,000 people in chat. Occasionally, people get timed out, blocked, and the moderators do an amazing job here. But occasionally, it happens by accident because the chat's moving really quickly and they intend to either just delete a comment, people get blocked, or whatever. That happened one day, and when that does happen, I have to go into YouTube. Does not make it easy to find that. You can't search for people who are blocked. You have to go through a list of, I don't know, hundreds of names. And when I did that one day for a person who was mistakenly blocked, I found that hoodie guy on that list. So it seemed like that hoodie guy had been causing trouble in here at one point and had been blocked from a very, very, very long time ago. So, that makes me think that that hoodie guy kind of was stirring up trouble. And who knows if even that hoodie guy was even telling the truth. So, I mean, I didn't really think that was a great argument, but just goes to show if you are someone like that hoodie guy and you go in, if you go in the Law and Crime chat, you will see a lot of people in there that claim to be certain things that they're not beyond fake names, kind of like many of the other social media platforms. So again, this person could have just been making stuff up. Who knows? And the judge has to believe what the jurors are telling him. So there's that, or assess their credibility. And he determined that he did not believe anyone had a cell phone in there. And maybe that hoodie guy was just, off the rails. Who knows? Back to the document. A defendant is entitled to a new trial if a juror is guilty of misconduct that prejudices the defendant's substantial rights. Once juror misconduct is established by juror interview, the moving party is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. The specific misconduct alleged in this motion is a juror's potential communication of the jury's thinking or impressions to a member of the public. There is no allegation that any juror received outside information during deliberations that might have prejudiced defendant's rights or affected the verdict. And they are citing a case that stands for the proposition that finding a reasonable possibility that a juror's use of a smartphone to look up the definition of prudent affected the verdict. Moreover, the juror interview did not produce any evidence showing that a juror possessed or used a cell phone during deliberations. Accordingly, defendant's motion for a new trial based on the use of a cell phone during deliberations is denied. And this is where I'm going to disagree with the judge. Because, I mean, unless I disagree with the judge, we wouldn't really talk about, right? Okay. This is the non-disclosure by juror 15, which we covered at length. There's a long playlist on Ashley Benefield. You can find the prior. I may have even linked them in the video show notes here, where we went over the original motion and the opposition to the motion, and then the hearing. I can't recall if I did that. Defendant alleges 3 instances of juror 15's failure to disclose material information during voir dire. First, defendant claims juror 15 failed to disclose having been a victim of crime. Second, defendant claims juror 15 failed to disclose having been involved in domestic violence, courts. Third, defendant claims juror 15 failed to disclose having been involved in a child custody dispute. Juror 15 was present with her attorney for the juror interview. So juror 15 showed up with a lawyer who was present when the judge interviewed her in camera. And of course, the prosecutor and the defense attorney were there as well. During voir dire, okay, this is also, I'm going to break again, to say this is also where lawyers can learn how to preserve the record in the future. And this is going to be a very important lesson in clarity of the record during voir dire proceedings. I don't think that voir dire was videotaped in this instance. I think there was only a transcript. If I'm conflating my cases, let me know. And this is why when we talk about testimony and we talk about clarity in the record, like when a witness is testifying and they say, oh yeah, he came at me and he hit me over here. And a thorough attorney will say, please note for the record that the witness is pointing to his right shoulder or the front of his right shoulder or the back of his head, so that the record is clear. Because when you get a transcript or a trial transcript back, it is usually, at least in New York, it is in book form. It is like a script, question, answer. It is a written document. In Massachusetts, we've been seeing a lot lately, like Madam Court Reporter in the Reed trial was speaking into what looked like an athletic cup during the course of the trial. That is a voice recording, which then needs to be transcribed. In New York, we still use the old-fashioned court reporters who have the machines where they type everything in, right? The clarity of the record is so important, and this is going to just teach lawyers going forward, if there's any law students here, if there's anybody out there who wants to be a trial lawyer, even practicing attorneys, how important it is to make the record clear. And here's why. During voir dire, the court provides each juror with a paddle that has a unique number for that juror, 1 through 70. Jurors then raise their paddle in response to questions. The transcript of voir dire reflects when there was a show of paddles, but it does not identify the specific jurors who raised their paddles unless the court or one of the attorneys calls out the number of each juror responding to a particular question or issue. And so I'm going to break to say that if I were an attorney in Florida, and this, I don't know if this is only in Florida, maybe every state is different. Maybe some record the proceedings. Maybe some court reporters say, after the attorney asks the question, the following paddles were raised in response to this question. Paddles number 6, 10, 15, 24, so that we don't have issues like this in the future. So here, Juror 15 testified in front of the court in this in-camera hearing that she reviewed select portions of the voir dire transcript and noted the instances when she raised her paddle in response to questions. Okay, so now we're going back and we're relying on Juror 15's memory of when she may have raised her paddle. And we're also going to rely on her whether or not she's telling the truth. Is she being truthful? Because if she lied on the questionnaire, who's to say she wouldn't lie on when she raised her paddle, knowing and having been advised by her attorney who's with her, there's nothing in the transcript that says when you raised your paddle. Guide your actions accordingly. I don't know. Not knowing whether or not she could be charged with some kind of perjury, right? These instances are identified by page and line number in a letter submitted by counsel and presented to the court and the parties during the juror interview. So, Juror 15 and her attorney went over that transcript prior to this hearing and wrote a letter to the court saying, we went through the transcript and here's when she raised her paddle. Juror 15 testified the contents of this letter accurately reflect her recollection of the occasions she raised her paddle in response to questions. A juror's non-disclosure of information warrants a new trial if 1, the information is relevant and material to jury service in the case. 2, the juror concealed the information during questioning. And 3, the failure to disclose the information was not attributable to the complaining party's lack of diligence. And then they go on, the court goes on to define these terms for us. Information is material if its disclosure likely would have resulted in a peremptory challenge, such as information that reveals an inherent bias for or against a party. Okay. Everyone comes into jury selection with their own personal experiences, their own personal feelings, their family history, their prior litigation experience of being a party to a lawsuit or a party in a domestic violence proceeding or a victim or a perpetrator or having those kinds of things in their families. And jury selection is so, I cannot emphasize enough how important jury selection is. We talked to Tom Kokakowski about that as well, Kokanowski, and about the Brian Camp trial. And he went through with us all of the questions that he asked the jurors. Do you own a firearm? Have you ever been the subject of a home invasion? Have you ever fired your gun at someone? He went on and on and on because these just are such important things to ask when you're picking a jury, so that you can try and weed out bias. And if there's bias, you can dismiss a juror for cause. And then you also have a certain number of peremptory challenges that you can use just because, I don't know, you thought a juror looked at you for whatever reason. Every state is different with the number of peremptories that you have. And so weeding out that inherent bias and people's personal experiences, because jurors don't leave their common sense at the door, just like they don't leave their personal history at the door. Weeding that out during jury selection is, in my opinion, one of the most important parts of being a trial lawyer. Anybody remembers the TV show Bull? Bull was a jury consultant, and he had an entire firm, and that's what he did. He consulted, and I think it was based on Dr. Phil, I think, right? And it was Michael Weatherly, and it was a fantastic show. They had mirror jurors, and it's important. In assessing the likelihood that disclosure of the information would have resulted in a peremptory challenge, courts consider whether the complaining party further questioned or ultimately challenged other jurors who disclosed the same information. Materiality is analyzed on a case-by-case basis. I mean, listen, the fact that she had an attorney who obviously went and read all of the case law and knew what had to be proven, I'm not saying that it was wrong of her to hire an attorney. I absolutely felt that she should have hired an attorney. But again, I'm going to disagree with the court's reasoning here, but let's get to it. Concealment of information need not be intentional to warrant a new trial. Unintentional concealment of information requires a new trial if it prevented counsel from making an informed decision, and the informed decision likely would have been a peremptory challenge. In showing concealment, the moving party must demonstrate that the voir dire questions at issue were straightforward and not reasonably susceptible to misinterpretation. The juror's answer to an ambiguous question cannot form the basis for a new trial. To satisfy the due diligence prong, the moving party must show that counsel sufficiently explained the type of information being sought from the potential jurors, especially when the average lay juror may not have a working understanding of the subject matter. Well, that's really interesting, Your Honor, that you put this in this decision denying a new trial, that we need to explain the type of information being sought from jurors, especially when the average lay juror may not have a working understanding of the subject. You mean like the working understanding of the fact that they should just know that they were entitled to have readbacks of testimony during deliberations? Like that kind of thing? Because they didn't say the magic words. Somebody reminded me that's what we said during the trial. During the magic words, that they didn't say the magic words, asking for a readback, so they didn't get the readback. Team Brittany says, is it a coincidence that Juror 15 has now been a thing in 3 trials? It wasn't always Juror 15, though, right? It was juror number 1 in the Maya Kowalski case. It was the egg lady juror in Murdoch. And this one, tell me if there's another one that you're thinking of. Joanne, I have I'm gonna star this question for later. Because we can talk about that. Because I have so much. Thank you, honestly. Thank you, honestly. Thank you a lot. Let's just get through this and then I'll come back to some questions, okay? So that interests me here. The average lay juror may not have a working understanding of the subject matter or the law or the definition of reasonable doubt. You know, because we're watching so many trials together now, we're starting to see some things that need to be changed. The jury instructions in Massachusetts, in my opinion, need to be changed. They were hella confusing. The judge in the Karen Reed's case said, do not come back with any verdict sheets filled out until you have reached unanimity on all 3 counts. Do not fill anything out. It was confusing. She also said, I'm going to give you the written jury instructions to bring back, but I'm also going to tell you some stuff. And so whatever I tell you is going to be take precedence over whatever it is that I'm giving you in writing. Hella confusing. The movement must show that counsel made inquiries to develop information that would have caused the movement to challenge the juror in question. Number 1, this is all with regard to juror 15, failure to disclose being the victim of a crime. The juror questionnaire asked prospective jurors whether they or a member of their immediate family had been the victim of a crime. Juror 15 testified that she answered no to this question. During the juror interviews, she confirmed that she filed a petition for an injunction for protection against domestic violence in 2016 that alleged her then boyfriend grabbed her by the hair and struck her in the face. In explaining the thinking behind her questionnaire answer, Juror 15 testified that she did not associate domestic violence with being the victim of a crime, contrasting domestic violence with being shot or raped. Mental gymnastics. Says Cat, hi, Cat Randall. So tell me if you think that that is reasonable to not associate being the victim of domestic violence. And this was 2016. Some of these things that she's questioned about happened a lot further away in time, in the early aughts, let's say. That her then boyfriend grabbed her by the hair, struck her in the face. She didn't consider that to be a crime. And I don't even know what this means. Contrasting domestic violence with being shot or raped. That DV is not a crime. She also stated that her injunction was denied, so she did not get her restraining order. It was apparent during the juror interview that juror 15 did not consider herself a victim of a crime because no criminal charges were filed and her injunction was denied. Okay, I'm going to just say right here that if you're raped and no one's ever arrested and no criminal charges are ever filed, does that mean that you're not a victim of a crime? And I'm also going to say, well, she's saying that she didn't think that domestic violence was a crime, Constance. I think that's the very, very slim difference here that the judge believed her about. And listen, we didn't meet the juror. We didn't see the juror. We didn't listen to anything that the juror said. So it is hard to assess credibility of someone when you can't see their face and their demeanor and their testimony, which is another reason in the Karen Reed trial why the defense wanted the trial moved to a different courtroom, which happened to be a much smaller courtroom, because many of the jurors from the vantage point in that big courtroom were going to be looking at the back of witnesses' heads. And the argument was, Your Honor, the witnesses have to see the faces. I mean, the jurors have to see the witnesses' faces. And my argument was, how could you assess someone's credibility without seeing their face and their body language and their posture? And Judge Cannoni was like, well, we've done it this way for 100 years. And Misty and Atty or Alan Jackson Smith is better said, well, I don't care. Have you done it for 100 years? That doesn't mean it's right. So it's hard for us to assess her credibility because we did not question her. We did not get to see her demeanor. I do not know. She may have made a very good impression on the judge, apparently. But I would submit to you that if a woman is raped, and just because no criminal charges were filed does not mean she's not the victim of a crime. And I don't really think, in my opinion, that a reasonable person reading this questionnaire would say, oh no, I wasn't a victim of a crime. He just pulled me by my hair and smacked me in my face. And that's not criminal. Because, it was my boyfriend. And if this is what we're teaching our daughters, I am frightened every single day in the pit of my stomach. It's not what I teach my daughters, but it's decisions like this that give me pause. Defending claims disclosure of this information would have at a minimum resulted in a peremptory challenge. The state argues this information was not material. The court agrees with the state that the information was not material. It wasn't material that this woman had filed for an order of protection against her boyfriend a couple of years ago, who pulled her by the hair and struck her in the face. And that when people make complaints, a lot of the times they try and minimize them. And then they drop charges. And then things like that happen. But in my own personal and legal opinion, I think that is incredibly material. The court specifically finds Juror 15 sufficiently disclosed her experience with domestic violence in response to other questions posed by defense counsel, and the record shows this information was not material and did not result in further inquiry or a peremptory strike. While defense counsel did not ask any prospective jurors about being victims of crime in general, counsel conducted inquiries into the specific issue of domestic violence, asking prospective jurors whether they had experienced an abusive man or knew someone who had, and whether they had experience as an abused woman or knew someone who had. Juror 15's testimony reflects that she responded affirmatively to these questions by raising her paddle. Well, that's what she told the judge. That's why it's so important to make the record clear during voir dire. Let the record reflect. Juror 15, Juror 17, Juror 23, Juror 40 have raised their paddles. As the state correctly observes, Juror 15's experience with domestic violence by her then boyfriend makes bias against defendant especially unlikely in this case, given defendant's theory that she shot her husband in self-defense. I completely disagree with that statement. I completely disagree. I have seen so many people in this chat and others and in comments saying Ashley wasn't the victim of domestic violence because he never physically punched her or hit her or dragged her by the hair. I think that is an incredibly flawed argument. Tell me what you think. This juror who experienced this could have said, oh, that's nothing. This guy never even touched her. He just shot a gun in the wall, punched the dog, threw the cat down the stairs. She wasn't abused. I was abused. She wasn't abused. But I wasn't really abused because I didn't even think it was a crime because I didn't even write it on my juror questionnaire. So in my opinion, this reasoning right here, incredibly flawed. I'm going to read it again. See, oops, that's not, I wanted to make a little arrow. Oh, and it's behind me anyway, so there. The court says, and says that the prosecutors are right, as the state correctly observes, Juror 15's experience with domestic violence by her then boyfriend makes bias against defendant especially unlikely. In this case, given defendant's theory that she shot her husband in self-defense. Strong, hard disagree. Citing this case, every case should stand on its own merits, by the way. I don't think that case law is really applicable here because every case is different, especially cases involving such complex things as domestic violence, which does not have to be physical. I don't understand why people don't get it. Johnson v. State is what he cites for his opinion here. Finding bias against the defendant was especially unlikely where the undisclosed information revealed the juror to be similarly situated to the defendant. Similarly situated. They are not. This woman who was dragged by the hair and punched in the face by her then boyfriend is not similarly situated to Ashley Benefield. Every case is different. To the extent defendant argues Juror 15 failed to disclose that her son had been charged with committing a battery against his girlfriend in 2014, who, by the way, was pregnant. He doesn't point that out here. This information was not responsive to the question about family members who had been the victim of a crime. And defendant does not allege any questioning during voir dire called for Juror 15 to disclose this information about her son. But I think it said, has anybody in your family ever been charged? Remember, her son was also the son who was something like 4 years old when her first husband, when she was the perpetrator of DV against her first husband and saw all that stuff happen and then grew up to be charged with abusing his pregnant girlfriend physically. It's the cycle of violence. It's about breaking generational curses. It's about, it ends with us. There's a movie. Everyone should have their daughters watch it and sons. Because yes, men can be victims of DV as well. Some of them are in this chat right now. Pregnant with her grandchild, who's a family member. Thank you, Jamie. Jamie, I'm so glad you're here. And so many of my other attorneys, I think, are here as well. Stephanie, I think Stephanie's here. I hope Peter Atragos does a video on this because I would love to hear his opinions. He is a Florida-based attorney. He has a lot of experience in Florida courts, has had probably, I'm sure, cases like this, knows about downward departure and the way Florida judges think. And I would love to know his thoughts on this. Peter Tragos, lawyer, you know. I'm sure he'll probably, maybe he'll have, I don't know if has he covered this case? I don't know. Accordingly, defendant's motion for a new trial based on Juror 15's failure to disclose being the victim of a crime is denied. Number 2, involvement in domestic violence courts. This is again with regard to Juror 15. During a voir dire, defendant's counsel asked prospective jurors, has anybody in the prospective veneer been involved in domestic violence courts? I'm not going to ask you what it was or why. I just want to know if anybody has been involved in domestic violence courts. This is what Neil Taylor asked during voir dire. Juror 15 testified during the juror interview that she did not raise her paddle in response to this question, but she confirmed, in addition to her filing the 2016 domestic violence petition discussed above, that her ex-husband filed 2 domestic violence petitions against her in 2003 and 2004. And by the way, I'm breaking to tell you, the only reason that she's admitting to all this stuff is because Neil Taylor came in with receipts on this. He had all the receipts of all these prior court proceedings. When the court asked Juror 15 to explain her thinking for not raising her paddle, when this question was posed to the veneer, she testified that the 2003 and 2004 petitions were dismissed without injunctions being entered and no charges were filed on the 2016 petition. As a result, she misunderstood what defense counsel meant when he used the term involved. This court finds Juror 15 credible in her testimony and explanations as to her response to this and the other questions posed to her. Here's the question again. Has anybody been involved in domestic violence courts? I would submit to you that when you have to go to court because your husband is seeking a restraining order against you twice in 2003 and 2004, that you've been involved with domestic violence courts, even though those petitions were dismissed and the person did not get the order. Look at even Scott's like, I'm not buying her reasoning. Again, I did not interview her personally. The judge did. He found her credible. I'm not buying it either, Scott. And by the way, if you did not watch Glare last night, Scott called into Glare, the earlier show, not the one he did with Nurse Kim. No, it wasn't. It was what? I'm sorry. It wasn't Glare. It was Young Jerks. And Scott, props to you on that phone call. It was a great phone call. People learned a lot from what you had to say. And another New York law enforcement officer who's still on the job, who also called right before you called into Mike at Young Jerks talking. They learned a lot from what you guys had to say on those calls, so good on you. Defendant claims disclosure of this information would have at a minimum resulted in a peremptory challenge. Specifically, defendant argues the details and facts underlying the 2003 and 2004 petitions closely resemble defendant's assertions against Mr. Benefield and made Juror 15 similarly situated to the victim in this case. The court finds the defendant is not entitled to relief on this claim for 3 reasons. Number 1, the defendant fails to satisfy the concealment element because counsel's questions about being, quote, involved in domestic violence courts, end quote, was vague and ambiguous. Do you find that vague and ambiguous? When he said anybody who's been involved in domestic violence courts, are we going to say that he also meant Did you ever work in the domestic violence courts? Were you ever, did you ever go in there to use the restroom? Were you ever involved by, interning when you were a student to file papers in the courts? Like, I don't find that vague and ambiguous. But that's just me. And some people think, like Duckgate conspirator, she was sandbagging to get on the jury because of her own bias. It's possible, right? Juror 15 credibly testified that she was uncertain what the phrase, quote, involved in domestic violence courts, end quote, meant. And the court finds the ambiguity of the question renders it reasonably susceptible to the misapprehension expressed by juror 15. Come on, really? Really? I'm not buying it. Jamie's a lawyer. DV courts is descriptive. We have probate courts here. I'd never ask about that. I'd say family court or child custody court or something like that. So you think that it would be something broader? You're in Florida? And aren't they called like chancery court? I think in Mississippi they were chancery courts, right? Where these kinds of things were heard, or maybe custody. I don't know. Second, the court finds any concealment of this information was attributable to counsel's lack of diligence. So that's Neil Taylor's fault. A lot of people in the chat didn't like Neil Taylor. I thought he did a great job. We're going to go back and talk about that a little bit. The Monday morning quarterbacking of, people thinking that he's not a great lawyer. And I just want to point out to you that being a trial lawyer is really, really hard. Not everybody can do it. So it's kind of easy to watch trials and be like, oh, that lawyer stinks, that lawyer stinks, that lawyer stinks. You cannot like their style. You cannot like their demeanor, as I am not a big fan of the prosecutors in this case, as I've not hidden. I think that it was gross the way she was treated. We watched an amazing prosecutor in Boulder during the horrific King Soopers shooting trial. His name is Michael Daugherty, and he worked, and coincidentally, like small world time, he worked in the Manhattan DA's office with Mark Betterow. Mark Betterow knows him very, very well. Michael Daugherty, in my opinion, is one of the best prosecutors I've ever seen because of his demeanor and how kind he was to the witnesses. And how kind he was even in just speaking about the defendant, who was a mass shooter. I mean, such a difference. Counsel did not offer any explanation, clarification, or examples of the type of information he was seeking about involvement in domestic violence courts. Just as attorneys must take care to use terms understandable to an average citizen when inquiring into prior litigation history, attorneys must also ensure the average juror understands what prior involvement in a court entails. I don't know. To help jurors, usually lay people with limited experience in the law and courts, this commonly takes the form of explaining what certain legal words and concepts mean in layman's terms, providing specific examples of what the question is asking for, and breaking a legal topic down into steps and asking jurors if they are familiar with or have had experience with each step. To me, I think that is self-explanatory, but domestic violence courts, any court in which a domestic violence proceeding was heard on your behalf or against you, I would say, or any member of your family. Maybe he should have been more specific. That's what the judge seems to say. Third, even if this claim satisfied the concealment and due diligence prongs, the record refutes defendants' claims that Juror 15's disclosure of prior involvement in domestic violence courts would have resulted in a peremptory strike. Oops, that's a terrible line I just drew. Defendant primarily argues the allegations against Juror 15 in the 2003 and 2004 petitions closely resemble defendant's assertions against Mr. Benefield in retaliation to this case. But when asking about prospective jurors' involvement in domestic violence courts, counsel expressly stated that he would not ask what it was or why. In keeping with his promise not to seek out any details, although some prospective jurors responded in the affirmative, counsel did not ask for any further information on the topic. Thus, even if juror 15 had responded affirmatively to the question, the record shows counsel would not have sought or obtained the factual details defendant now attempts to rely on. Defendant also argues counsel's challenge against juror 51 supports the claim that an affirmative response from juror 15 would have led to a challenge, but the record does not support this claim. According to the affidavit of Jack O'Keefe, who assisted counsel during voir dire, the two prospective jurors who indicated involvement in domestic violence courts were jurors 51 and 52. The court did not reach juror 52 when selecting the jury, but defendant emphasized counsel challenged juror 51 as reflected in the following exchange. Mr. Taylor, I have two left, Judge. Juror 50 is one. She had a pretty strong opinion about guns, but also added, and I think this was the kicker, that she cannot judge others. The court, state, Ms. O'Donnell, Judge, I would agree to that. The court, yeah, she also said no one should have guns, so juror 51 is for cause. This exchange is unclear as to the identity of the prospective juror being dismissed. I don't know, it kind of says juror 51 was dismissed for cause. But even assuming it was juror 51, the challenge was unrelated to prior involvement in domestic violence courts and does not support defendant's claim that counsel would have exercised a peremptory strike if juror 15 had disclosed unspecified and unelaborated involvement in domestic violence courts. Yeah, but juror 51 was dismissed for cause, not a peremptory, because juror 51 said, I don't think anybody should have a gun. Okay. Accordingly, defendant's motion for a new trial based on juror 15's failure to disclose involvement in domestic violence courts is denied. 3, disputes about child custody. During voir dire, the prosecutor asked 2 questions about child custody disputes. Have any of you here ever had any disputes with your significant other about your child or the custody of your child? And has anyone here ever had a heated custody battle with anyone? No, I will hate corrupt. Thank you for bringing this up. Matthew Farwell's court today was adjourned to February. They're kicking that can so far down the road. Thank you, Hate Corrupt, for bringing that up because I forgot to tell you guys. It was adjourned to February 4th. So thank you. I saw some other people in the chat talking about YSL and some other things, but I think we sort of like put the kibosh on that because I don't really know what happened, so I couldn't really talk about it. And also it was kind of derailing the subject of why we were here. But I don't really know what happened with the YSL trial. I really didn't even follow that trial. It's been going on for, I don't even know how long, a year or more. Yes, Scott, thank you for finding my words. They don't want anything with Farwell coming out to help Karen or Aiden. Could be. Could be. BL, if there's been new filings in Reed, then we'll probably cover that later. If anybody can email, I haven't even checked my email while we've been on here like this whole time. Well, I'm here. Thank you, B Harmony, for buying me 3 matcha lattes. I appreciate you. Who says that he or she loves me and that I'm a class act. Thank you so very much. Appreciate you. And Ms. Melly bought me a matcha latte. Thank you. Seems to be a lot of Melanies on YouTube. The internet trolls will never stop. Nope, no, they won't. Marie bought me 5 matcha lattes. Thank you so much, Marie, for your compliment and for your 5 matcha lattes. I'm going to need every one of them today. Every single one. All of the matcha lattes. So I appreciate you. Thank you so much. So much. All right, back to the document. The record reflects that the prosecutor made further inquiries inquiries into this issue with 6 prospective jurors, none of whom were juror 15. The record does not indicate whether the prosecutor individually followed up with every prospective juror who responded to these questions, and juror 15 did not recall if she raised her paddle. So she didn't recall if she raised her paddle about child custody disputes. During juror interviews, juror 15 testified that she and her ex-husband had a negotiated agreement as to a custody and time sharing when they separated. The 2003 and 2004 domestic violence petition that incidentally raised the issue of child custody were dismissed, and that she never appeared in court for the modification of child custody. She admitted to having heated conversations with her ex-husband about the topic after he started dating a new person, but when asked how she would respond to these questions at the time of the juror interview, she testified she would have answered no. Defendant claims disclosure of this information would have resulted at a minimum in a peremptory challenge. State argues that juror 15's explanation and proposed response are reasonable given the lack of explanation or clarification about what a child custody dispute entailed. Okay. The state also argues any non-disclosure is attributable to a lack of diligence because the defense did not ask any questions about the child custody during voir dire. Court finds that defendant is not entitled to relief on this claim for 3 reasons. First, defendant has not established that information was concealed. Neither the transcript of voir dire nor the evidence from the juror interview show that juror 15 failed to disclose information about child custody disputes. The transcript of voir dire does not indicate who responded affirmatively to the question, and juror 15 could not recall during the juror interview whether she raised her paddle in response to these questions. Second, any concealment of this information was attributable to defense counsel's lack of diligence. Okay, so he's blaming Neil Taylor here. Prosecutor conducted all inquiries into the issues of child custody disputes during voir dire, and the prospective jurors were never advised of the scope or type of information being sought with the questions. Defendant relies primarily on the ex-husband's allegations about child custody in the 2003 and 2004 domestic violence petitions, but juror 15 testified the petitions were dismissed and there were never any legal disputes about child custody. Based on this testimony and the ambiguity of the prosecutor's question, it is reasonable for juror 15 to believe the question was not applicable to her circumstances. Defense counsel did not seek to clarify this ambiguity and did not seek any information from prospective jurors on this topic. Third, the record shows information about child custody disputes was not material and would not have resulted in a peremptory strike if disclosed. Well, I don't know that we can get into the mind of the defense attorney here. Defense counsel's lack of any inquiry on this topic suggests it would not have received substantial weight in the exercise of peremptory challenges. Of the 6 prospective jurors individually questioned by the prosecutor on this issue, defense counsel exercised a peremptory strike against only one, juror number 4. While juror 4 acknowledged a prior dispute about child custody, I lost my place for a second here. They testified it was not contentious, did not go to court, and was resolved amicably. Defendant does not argue, and the record does not indicate, that defense counsel's peremptory challenge against this juror was related to child custody issues. Accordingly, defendant's motion for a new trial based on juror 15's failure to disclose disputes about child custody is denied. Based on the foregoing, be it now ordered and adjudged that the defendant's motion for a new trial, filed August 9th, 2024, is denied in its entirety, done in chambers in Bradenton, Manatee County, Florida on, he didn't even fill in the date here, but I believe it was the 20th. I don't know. It says it was filed on the 27th of November. And this was Judge Stephen with a PH, White with a Y, circuit judge. He was a very learned man. He knows a lot about the law. He's very thorough. It's a thorough decision. It's 11 pages. Let's go to the chat for your thoughts, concerns, venting. I agree with you, Sadie. Attorney Taylor did not lose this case. I thought he did a fantastic job. I don't think anybody realizes like how difficult it is. Tom Kokanowski told us that he prepped a year and a half for the Brian Camp trial, and that a year and a half. I think it was only a 4-day trial, right? Look at this. Moon God is participating in a mock jury for 2 days soon. That's amazing. That's amazing. I do not give out legal advice on this channel. And I do not respond to emails asking for legal advice or referrals to an attorney or reading somebody's legal pleadings and giving them an opinion. I don't do that, but I will strongly suggest to each and every one of you who is called for jury selection to please be 100% honest on your jury questionnaire so that things like this don't happen again. And to also raise your paddle if there is something that pertains to you so that things like this do not happen. And that's amazing. And I think everyone should serve, although I'm sure a lot of people don't want to serve anymore after what's happening and the jurors are being called back and questioned. And thank you, Hate Corruption, for gifting a membership. I appreciate your generosity. And to the new member, welcome. T-Fo-Ni, thanks for 5. So frustrated with this case. I was thinking it would be 5 or 10 years, although I think it should have been 0. This is gross. Thank you for your thoughts. Hi, Jadzia. I'd love to hear Laura Richards' thoughts on this case. Crime analysis. She petitions for changes to law and perception of domestic violence and coercive control. I think someone else had pointed her out to me one time. Is she in the UK? I mean, I know that somebody, it may have been you, who I didn't know who she was, but I'm going to write her name down. I'm never going to forget from this case the testimony of that one detective who came in and was like, just did not believe, got annoyed at Ashley for calling him, asking him when he was going to arrest Doug Benefield for his violation of the restraining order and just his disdain for her. And I think there needs to be better training. But anyway, Jadzia says, I'd love to hear, she petitions for changes to law and perception of DV and coercive control. That's, thank you, Jadzia. I don't know how to reach her, but I will look into it. Read on my book says, FYI, SJC approves new rules on criminal pretrial discovery today, effective March 1st, 2025. Thanks. Did you email me anything on that? That would be amazing. I do not respond to all emails, but I do read all emails. In fact, it was a viewer who pointed me to the Brian Camp case. So thank you for that. I appreciate you as always. Loudmouse says, my ex used to beat the snot out of me, but the judge kept giving him a break because he was a teacher and a coach. The judge was concerned that his guilt would affect his occupation. I poop you not, she says. I'm so sorry. Thank you for your super chat. Hate Corrupt, thanks for the super sticker. Joanne Pollock says, why did the judge list all downward departure items he agreed with, not understanding this at all? He is protecting the record on appeal. There will be, I'm sure, an appeal on the sentencing and an appeal on the denial of this motion for the new trial that was just denied based on juror misconduct. And under the rules of Florida, as the judge explained to Ashley, who looked just completely broken, my heart breaks for Emerson. She has 30 days to file, or her attorney does, a notice of appeal, which is basically just like a one sheet saying we intend to appeal. Here's our fee and our one sheet. And then you have months to file briefs and all of the other things that are involved in appellate work. And Jamie says, guys, there are 2 prongs for downward deviation. 1 is their cause, yes. And 2, judicial discretion. And he said, this isn't the type of case that gets a downward deviation. Wasn't that at the end of everything that he did after saying all of those things? Like he found her credible, her testimony credible. He's allowed to consider her testimony. She doesn't have to speak at the sentencing. And I was a little catfished. Whole thing. Lois, will you sing the Glare super chat song? Just kidding. Just wanted to make you laugh. No, I think I got a super chat. But thank you. Thank you, Lois, for trying to make me laugh. For giving me a 20 to do it. You guys are amazing. You are very, very, very funny. There's really nothing funny about today at all. Do not know where we can write Ashley because we do not know. Is there only one women's prison in Florida? I don't know. I'm not familiar with the prison system in Florida. I don't know where they're going to put her. I do believe that most states, almost every state, has like a public database of inmates and where they are housed, and that somehow you could find out really where any person who's incarcerated in a state prison system is, and the address and where to write to them. So we don't know. I don't know right now exactly. Paddle in a loon says I'm on the replay. This was such an injustice. We watched Ashley Benefield sentenced to 20 years in prison today, and no downward departure. And then after her 20 years, she's going to get 10 years of probation. And thank you also to the anonymous matcha latte gifter who says, thank you so much that it's Fairy Raven from Ireland. Says that I'm a wonderful role model. Thank you. Thank you, Fairy Raven, for tuning in from Ireland for your matcha latte. Let us see. Let us go back here, see if there are any other questions because it's been a long morning. Right. Sarah Boone's left kidney. I don't understand how the judge can say he finds her credible and that she was acting in self-defense and then gives her 20 years plus 10 years. Makes zero sense to me. I mean, we watched Sarah Boone yesterday get life. How can why am I forgetting what happened yesterday? And I'm so careful I don't put the titles in my streams. I mean, I don't put because I don't want to give anybody the spoiler alert of what happened. I want to kind of give them the, if they haven't seen it, give them the opportunity to watch it in their own real time without reading comments. Right? So, I mean, we look at so many different cases and we see so many different, it's wild, the swing from state to state, the laws that differ from state to state. Carly Gregg sentenced in Mississippi at 14 years old when the crime was committed, tried as an adult, was the first juvenile to be sentenced under the new guidelines that said it is appropriate to sentence someone under the age of 18 to life without possibility of parole ever. And we watched that happen in the Carly Gregg case. Yeah, we got to do that podcast. We got to do that podcast. Those ducking timwits. So I guess in the grand scheme of things, 20 years is not life, but life wasn't on the table here. I think the max was 30. So the answer to this is yes. Can the defendant go to the appellate courts in Florida to overrule the judge's decision? Yes, they can. All the things. They can do it for all the things. Well, the judge said you didn't object during the closings, so, you waived it. Trial lawyers all over Florida. Trial lawyers all over Florida have learned a lot of things today. A lot of things, because you never stop learning as a lawyer. You never stop learning. Case law is constantly changing. Statutes are constantly changing. New laws are being enacted. So a lot of lawyers find it in poor form to object during a closing. A lot of lawyers think it's totally cool to object to a closing every 5 seconds and throw off the rhythm. And every state differs. And the judge here said, you didn't object. You waived it. Oh, is Tom here? Hi, Tom, if you're here. Let's do another show. I need you to talk me off the ledge on this one. Better just had a case with a female DA who acted similarly unsympathetic towards a DV victim and charged her. The duck sauce killer case. Look at you getting all the deets on all the sitches of all the cases that Beto handles. That's amazing. Let us see where we are. Oh, there's one toy. Constance says there's one toy left on the camp girls wish list added yesterday by Tom off the girls' personal list. That's amazing. I was advised by Brooke's friend. I don't know, Tom, are you here? Can I share the news? I was being emailed by Brooke and Brian's friend. Oh my gosh, Donna. Thank you for the 10. I'm a DV survivor. My ex set our home on fire, killed my pets, but he never hit me. Nightmares still tonight after 35 years. My heart breaks for you. So again, under what we just learned in Florida, he never hit you. And you were in Florida and something happened and you defended yourself because he had never hit you before. Apparently, these prosecutors would have thought, no big whoop. You didn't have a right to defend yourself. Donna, there are no words. Jenna says, love your live streams. My heart breaks for Ashley. Sarah Boone, on the other hand, I bet she's wishing she took the plea 15 years. Yeah. 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 It was Jamie Komorowski yesterday that got 25 years for the drunk driving. And for killing, she was 3 times over the legal limit. And then 20 years for Ashley today. Life for Sarah Boone. But on a really nice note, you guys bought bought out the entire wish list for the camp children. I hope they add some more stuff to it. And even like Tom, if you're here, I wish that Brooke and Brian would add some gifts for themselves as well, because they all deserve a very nice Christmas. Oh my goodness. Somebody sent me a letter that was sent to the court that mentions my name for Ashley Benefield. Wow, that's interesting. Thank you, Anna, for sending me that. I'll read that later. But there is something that I wanted to say to you. So this was 4 days ago. So this was on Friday. Brian was acquitted, last Monday? Brooke's friend wrote to me and said that Brooke is currently adding some more items to the wish list. What an amazing thing. Brooke and I were both watching a little as well and texting back and forth, talking about the show that I did with Tom Kokanowski, Brian's attorney. Said that we have an amazing community and that we are amazing and you are amazing, you guys. And she said she also just informed me that Brian proposed today, which I thought was so heartwarming. So there's a nice little story. There's a nice little story after the 2-year nightmare that Brooke and Brian went through and their 2 little girls went through. Hopefully they're going to have a nice Christmas. And Brian proposed to Brooke a couple days after the acquittal. Isn't that amazing? Amazing. They have 1 child together and 1 child that Brian loves like she's his own. And that is so heartwarming. Right? Oh, look at DMC, aka Lady Die 2, getting chills. Going to the chapel and I know, Lori, that just made me so happy. So there is some good news in all of this. And I know that you also adopted Brian Camp as your adopted child, as did I. He was our collective adopted child. Can we possibly add a secure gun cabinet for Brian now that the girls are getting bigger? That's a great idea. That is a great idea. Hang on. I got to scroll through a lot of comments here to get to where I need to go. So talk amongst yourselves for a minute. Yeah. Can we give Tom an honorary cupcake? Tom needs to become a cupcake. I'm trying to find his comment, but there's a lot of comments here, so hold on. There he is. He's here. Hi. Yes, so our request is that lots of more things get on the Amazon wish list. There's a lot of people here who are in a really generous and giving mood, and they would love to see some engagement gifts, some gifts for Brooke and Brian. And I know that they are very humble and that they don't want to, like, a lot of people feel funny, like receiving things from strangers, but there are so many people who just, it makes them feel good to give things to people, I think. And so, I mean, that's who's here. That's the kind of people that are here. I don't know what the GoFundMe is up to yet. Let me just take a look at that. Let's see where that was. I think when we did that stream, right before we went live on that, it was at something like $500 for the Brooke and Brian's family rebuild GoFundMe. And now it is up over $4,300. So thank you all for your generosity, for your kindness, for your understanding, and for your search of the truth. The links, if you would go to the last stream that I did on Brian Camp, the show that I did with Tom, can you just go back to the show notes? They're right in there. Okay. All right, you guys, this has been a long one already. It's 4.5 hours. Thanks for hanging in with me. It's every time we get a win, it's like we get knocked down again. Feels like, right? So, but here we are, and we're doing the things, and we're talking about the things that matter, in my opinion. And thank you, Jenna Baby, for the 5. Love your streams. My heart breaks for Ashley. Sarah Boone, on the other hand, but she wished she took the plea. Oh, we did this one already. Congrats, Brian and Brooke, from your cupcake fans. Yeah, and that's amazing news. So there's some good happening this holiday season. And Tom says, treating himself to a new Tom James suit. Oh, that's hilarious. That's hilarious. I believe that I have a Tom James suit or two. And I forget her name, but years ago she used to come into the office, measure everyone. Pretty sure it was Tom James. They're all custom, right? They come, they measure you, they make the suits. They're not really in style so much anymore for the ones that I had from 20 years ago, but I think you should treat yourself to a new Tom James suit. We'll talk offline. All right, you guys, do all the things that YouTube likes, the YouTube-ish type things. Smash the like button, hit subscribe. Make sure you have the bell set for all notifications, and be nice to everyone. Thank you, moderators. This was really hard today. I mean, I had to keep tightening up the game here on who was allowed to chat because it was rough. It was rough. Just thank you, mods. I love you all. I love each and every one of you with all of my heart, and you and your generosity and your search for the truth and your fight for justice. So just stay cool, stay kind, stay classy. You can do it. I know you can do it. You can do it. It's hard. Peace.